No.
103.
For 1 hour. Says we're closing the doors at 5 o'clock, so.
Okay. Good afternoon. This is the CHamoru Land Trust Commission regular meeting, board meeting, Thursday, January 16, 2025. The time is 1:04. This meeting is, I need to do a roll call. Mr. Commissioner Harold Garrido.
Here.
Commissioner David Herrera. Commissioner Jeffrey John Ibanez. We have a quorum. I would like to do the invitation.
Kinini masakilum inasoku, imasakulum i coração de mas filho na nação. O oferecer mais azul para baixo por eles, a muito diferente, e lengue, e cultura, e linguagem, e a ele, e hano, da mitano CHamoru, e inchafu, su gini na staka. Este o afirma de Bíblia e bandeirão e bandeira Wama. Viva Toko.
Public notice requirements, Guam Daily Post, January 9, 25, and January 14, 25. Public notice website of the CLTC Facebook page. On the agenda, we would like to start, make a change in the order. We would like to go in executive session.
Madam Chair, let me verify court reporters here. Madam Chair, the court reporters will not be here till 1:30.
Okay. And on the other part of the agenda, we are going to discuss the new business, H, Robert Rules of Order, which has a time limit. Yes. Commissioner Garrido would present
Applying Robert's Rules of Order to the limit of time for questions during a CHamoru Land board meeting involves a few steps. 1. Establish rules at the beginning of the meeting. The chair should propose a specific time limit for questions, such as 2 or 3 minutes per director per issue. This should be communicated clearly to all members. 2. Motion to limit time. A member can make a motion to limit time for questions. This motion can be phrased as, I move that each director be allowed a maximum time of 3 minutes to ask questions during discussions. 3rd, a second to the motion. Ensure that someone seconds the motion so that it can be voted on. 4th, discussion. Allow for a brief discussion on the motion. Members can express their thoughts on whether the time limit is appropriate. 5th, vote. Conduct a vote on the motion. If the majority agrees, the time limit will be enforced. 6, enforcement. During the meeting, the chair should monitor the time. A timer can be used to ensure fairness. If a director exceeds the time limit, the chair can gently remind them to conclude their questions. 7, be flexible. If the discussion is particularly complex or important, the board chairperson may choose to revisit and extend the given time limit in the meeting. By following these steps, the board can maintain order and ensure that all directors have an opportunity to participate while keeping the meeting efficient. This control measure will enable the commission to move forward with assigning new leases for our unresolved constituents in residential, agriculture, and commercial leases. I highly advocate that we adopt this measure. This will allow the commission to continue to move forward with current agenda as well as fulfilling our mission statement. Effective governance is critical for the success and sustainability of any organization, and the power is embedded with the chairman. The chairperson's role extends far beyond simply facilitating meetings. As the leader of the Board of Commissions, the chairperson plays a critical role in providing effective leadership, ensuring open and productive communication, and guiding the board's focus towards strategic matters. The chairperson also possesses the responsibility of setting the strategic direction for the commission. The chairperson works closely with the board members and organization to establish long-term goals, monitor progress, and make necessary adjustments. Another significant challenge for the chairperson is navigating the dynamics of the board. Each board member brings their perspective, experience, and agendas, which can lead to differences in opinions and potential conflict. Chairperson must foster open communication, build consensus, and maintain harmony among board members to ensure effective decision-making and collaboration. One of the primary challenges faced by chairperson is managing conflicts of interest within the board and the organization as a whole. Conflicts of interest can arise when board members have personal or financial interests that may influence their decision-making processes. Chairperson must remain impartial and ensure that all board members act in the best interest of the organization. In conclusion, the role of the chairperson is essential in ensuring effective governance and strategic direction within an organization. The chairperson's leadership is instrumental in guiding the commission board and driving the success of the organization. By overseeing board activities, promoting effective communication, and fostering cohesion among board members, the chairperson creates an environment conducive to making informed decisions and achieving the commission goal. At this point, I want to place a motion on the commission floor to adopt my recommended time constraint consisting with Robert rules, a time limit for questions and discussion, 3 minutes per director per issue. That is my motion, Madam Chair.
A second.
All
Aye.
all in favor, say aye.
Aye.
It's open to discussion. There being none, motion carried.
Thank you, ma'am.
Madam Chair, board members, you may want to also consider time limit for the constituents who may be also speaking on behalf of their case. But again, it's up to the board. It's just something you may want to consider.
There's nothing in, do you want to start with your administrative report?
Madam Chair, I'm sorry, are we also limiting the time limit also for positions or for government so that I know at times we can go on?
Yes, that's why we have this, we adopt these rules. And if there's more time that is needed after the 3 minutes, it all depends on the approval of the directors.
No, but this is for positions. These are for open comments when we're discussing other factors, so we limit, and we have them just get this straight to the point, so that they don't just keep.
Yeah, that's the
This
purpose.
part is-
Yeah.
Madam Chair, Commissioners, if you wish to impose a time limit on constituents or members of the public who are speaking to you, that would, just as before, that would take a motion and a second and a vote.
Director Grace?
I don't know if the board would want to consider 3 minutes, 5 minutes, that's totally up to the board.
The constituents. Any discussions?
Open to discussion.
Madam Chair, if there is no discussions, I would like to make a motion to include time limits for the constituents, 5 minutes per issue.
I need a motion to second.
Perhaps a time limit based on the complexity of the subject,
Per issue.
right? Because if we're basically just discussing a small lot, let's say it's a successorship criteria, and the successorship is clear based on Title 21, Chapter 75, then it's a clear rules. But if the case is more complicated, where you have 2 or 3 or 4 constituents, let's say, so maybe subject to, or on a case-by-case, minimum 5 minutes, and then based on
No,
on a
not
case-
minimum.
minimum,
No, not minimum.
maximum.
Yeah.
No, so, if I mean, basically, if it's a simple, they have up to 5 minutes to discuss. If it's, and they can be a 1 minute to be short, but the maximum is 5 minutes. That allows for other, if it's open to the public,
Other
others
discussions.
who wants to come in and speak, we limit that amount of time. I mean,
Madam Chair, members, to Commissioner Herrera's point, as Commissioner Garrido pointed out in his earlier discussion, when we get to the 5-minute point, if a valuable discussion continues, it is at the discretion of the chair to add a few more minutes.
Understood?
So we'll need a second on Commissioner Garrido's motion.
Okay, I second Commissioner Garrido's motion for,
All in favor, say aye.
Aye.
Motion carried. Any discussion? That's it.
Madam Chair, that I'm told the court reporter is here. While they're getting set up, perhaps we could approve some minutes, knock that one off the list, and then we'll see where we go next on the agenda.
I do 3.
The approval, we need an approval for the minutes of September 19, 2024. This is the regular board meeting.
So, Madam Chair, may I make a motion to approve the minutes of October,
No,
subject to change,
September.
or September 19, 2020, subject to change?
All in, I need a second.
Second.
All in favor, say aye.
Aye.
Motion carried. The October 17, 2024.
Madam Chair, if I also may make a motion.
On the September, or October 17 meeting, under Administrative Director's Report by AAD JB Cruz, item B, second sentence there, it says, with Mr. Bill, an attorney advisor. Who's Mr. Bill?
Subject to corrections.
Yeah, that's what I'm reading it on.
I don't know what that should be. That's why I'm bringing it up.
Oh, there. That was
An attorney advisor.
That's not what Mr. Bill.
and they can go back into the minutes to clarify that.
You have a question? Your report,
This was in the report, Mr. Cruz.
So the one with SBA.
Item B.
Item B.
October 17th.
Okay, go ahead.
Is that correct? I just want to know if that's correct. Is Mr. Bill, the attorney advisor for SBA?
I don't recall if that's his name, but we can verify.
Other than that, I have no questions on the October 17 meeting.
So we need a second.
I second, Madam Chair.
All in favor, say aye.
Aye.
I'm sorry, first motion,
Commissioner
the
Revere.
read, Commissioner?
Motion carried. Now the October, the November 21, 2024 regular board meeting. Are the- Motion to approve the minutes is needed.
Madam Chair, again, I'd like to make a motion, please, to approve the October 2024.
November,
Is that November?
yeah.
Yeah.
Or November 21, 2024, regular meeting, subject to change.
I second the motion.
All in favor, say aye. Aye. Motion carried. Is there any discussion? There being none, we go into the, I don't have the December.
The resumption.
December 2nd and the 10th. Thank you. Okay. The resumption meeting of December 2nd, 2024.
I have no corrections or comments for that. That being the case, I'd like to put a motion on the floor to accept the minutes for the resumption meeting of December 2nd, 2024 at 1 p.m.
All in favor? Oh, you need a second.
Second motion, Madam Chair.
All in favor, say aye.
Aye.
Aye. Motion carried. Another resumption meeting
Whatever, when you get
On-
to get there.
December 10th, 2024. Need a motion to second? I mean,
Without any objections, I'll place a motion on the floor, Madam Chair. And we accept the December 10th resumption meeting. December 10th, 2024 at 1 p.m.
Okay, second motion, Madam Chair.
all in favor, say aye. Aye. Motion carried. Open for discussion. There being none,
Excuse me, Commissioner, Madam Chair. I don't believe I got the approval for October 28th on the third. It's a resumption.
The resumption meeting, October.
October 28th.
here, I got it. This is the resumption meeting of October 28th, 2024.
So, Madam Chair, I'd like to make a motion to approve the October 2024 subject to change.
I second.
All in favor, say aye.
Aye.
Motion carried. Okay,
Madam Chair, if we can just continue and allow me to go ahead of my administrative director's report. It shouldn't take too long.
go ahead.
Good afternoon, Madam Chair, Commission members. The first item I'd like to report on is the 1995 moving the line, the commencement of our lease process. As of today, we published 29 applicants to commence the lease process. Out of the 29, 4, the board had voted and decided to terminate 4 applications due to non-compliance, which was part of the initial 5 that we published when we commenced this process. 3 has been recategorized due to Public Law 37-131. What that entails is as we review the file of the applicants in the waiting list, we have determined that so far 3 files had fully executed leases that in file that did not have a decline form, but they were not ratified. Because Public Law 37-131 addresses the clouded lease, that is also considered a clouded lease, so it's been recategorized. Next is only 4 so far have complied with the requirements and the timeline to submit documents. We should be completing the eligibility verification process within this month, and hopefully by next month we present 4 applicants to be issued new leases. Unfortunately, 18 did not comply nor respond to our requests, and unfortunately next month we may be presenting 18 cases to the board for termination due to non-compliance. We have the next 25 already that we've been preparing. Files have been reviewed. We anticipate to publish that at the end of January. Again, we're going to issue out certified mails requesting for them to provide the necessary documents and update their contact information, and again, give them the 90-day window Because we've already established a process, we have that down pat already, we anticipate to commence the lease award process for 25 applicants at a time. As soon as we are able to fill the vacancies that we recently announced for, we'll gradually increase that number and it'll become higher as we go forward. And one thing to keep in mind is that as we process these applications for leases, we also have the other task of identifying available lots to be leased. So if I'm not mistaken, as of today, the board had approved about 300 lots available to be leased, which consist of residential and agriculture. But then again, as the months come and go, we'll be presenting more lots for the board to approve to be leased. The second item is compliance inspections that we have completed. For track 9210, we've completed 483 compliance inspections. In the municipality of PD, we completed 13. Municipality of Umatag, we completed 54. We've done compliance inspections related to the loan guarantees that are still pending. We completed seven of those. We've completed 2 compliance inspections on leases that have not been ratified. We've addressed compliance inspections in relation to constituent complaints. And then we also, again, completed 5 compliance inspections in relation to the constituent requesting for survey authorizations. So in total, about 569 compliance inspections have been completed. We roughly estimate that that's the same amount of notice to remediate that we'll be sending out through certified mail. So that's in regards to the compliance section. We just wanted to give you a little sneak peek at what end product is produced at the end of our compliance inspections. So as you see here on the board, when I first started working here in 1998, I used to be the boy luffing around these poster board type maps that had color codes to identify whether a lot was encumbered by a lessee or whether it was vacant, whether they had access or not. So we just wanted to present to you our sample of track 9210. So you see that we have one tax on certain squares or certain lots. That would mean, based on the legend, that those are vacant lots. It's sort of like our redundancy also to what we have digitally. We can go back and reconcile. But at the same time too, we identify accessibility. So the ones in green, there's no access. And then we have the whole lease listing of who are lessees within the area. We take this information, we cross-check it with our database to ensure that the data integrity is at the top of the priority to ensure. So this is what comes out of our compliance inspection.
When you mentioned there's no access, does that mean there's no right of way? Or just
Correct.
the access is not?
It's overgrown.
Okay.
Yeah. So it also helps us in our planning stage when we reach out to GPA or the utility company and figure out how we can get that place energized or water running through it. So we can already pinpoint where exactly there is no access due to overgrown. I believe 9210 was already cleared at one time, but due to our constituents not doing anything, it overgrew. The next item is our in regards to commercial, we did 2 commercial compliance inspections. The next item I want to report is the safety of our staff. Unfortunately, last week when our staff was conducting compliance inspections, about a lot or 2 lots down from the subject lot, they were conducting their inspection. They heard, we don't know if it was towards them or because they were there, but 30 gunshots. So immediately they called GPD. GPD responded and cleared the area and did whatever it is they did. We anticipate more of that type of activity happening, but nonetheless, this time going forward, we'll be reaching out to the mayors to let them know that we'll be in their municipality conducting compliance inspections, and if something like that should occur again, the staff has been informed to contact GPD immediately and do what needs to be done. The next item is our office space. We have not received any confirmation of our invitation for bid, if it has been potentially, or they have selected a potential vendor. But we do anticipate in the next couple of weeks, at the most, hopefully, that we get some kind of feedback on that. But definitely we'll request for a site visit or a site inspection to ensure that we comply with all the specs that we put forth in the IFB. The next item is affordable housing. I met with the Guam Housing Corporation, Ms. Edith Languden and her staff in regards to trying to figure out how we can address the housing needs of our constituents. Like we did in the past, we'll be providing them with our lease listing, and they will initiate contact to determine whether our lessee may be interested in applying for a loan, or if they could qualify and what they can qualify for. Definitely that will help our residential lessees with clouds within their lease to help them come into compliance if they have not done anything thus far. The next item is the water and wastewater. Like I mentioned in the past, we have and we continue to explore opportunities to obtain federal grant funding through USDA water and wastewater program. Again, assisting us with this process is RCAC, which is a nonprofit group out of Hawaii. About maybe a couple weeks ago, I sent a letter to GWA requesting to provide an estimated project cost for the installation of water and wastewater within lot 190-1-1, 190-1-R2, and tract 113, block 16, all within the municipality of Delito. And when we receive that feedback, then there's another process of determining who will complete the PER and the environmental assessment. I was informed by the individual from RCAC who's assisting us that USDA does have search grants that could supplement the cost for those reports that are needed. The next item is, we're coming to that time when we're gonna have to report to the Office of the Attorney General in relation to complying with the settlement agreement. So at this point, we're compiling data to prepare the report that we're gonna send to the Attorney General's office, who I believe in turn will report to the U.S. Attorney General's office. The report is mainly will consist of what we've done since our last reporting to today in relation to qualifying our constituents within the eligible beneficiary criteria, ensuring that a new employee or a new commissioner has taken the Fair Housing Act training, and providing them with the affidavits that we all fill out. The next item is, and I believe everybody was given a copy, is the introduction of Governor Lulian Guerrero's bill seeking to return lot 5173-1-R-R7 and lot 5173-1-R2-6 in the municipality of Tamuning to the heirs of Francisco D. Paris. The subject lots are also known as Okapoin or Ipao Point, the OGMH. And then the last item is regarding the board. The board already had started formed a subcommittee in regards to the GMA negotiation of a non-commercial lease we were thinking maybe the board might want to consider forming other subcommittees that are focused on like commercial, compliance, infrastructure. It will give the board members, just one board member, not members, but one board member per committee, firsthand knowledge of what we're dealing with, the magnitude of the projects that we're dealing with. It will also ensure that at least one board member is well informed of our process, may give their inputs into making our process more efficient and effective, things of that nature. The next item is the CLTC board has operated. This is not one time, but this is a time where there's 4 board members. We haven't had 4 board members for a while. The board may want to consider appointing a vice chair in the event the chairwoman is not available to ensure that our meetings will take place. What happened in the past when there was 4 board members and no vice chair, the chairperson would appoint a vice chair in their absence. It's just something for the board to consider, nothing to make a decision on now, but just something to bounce around. Madam Chair, my director's report is.
Thank you, and are there any questions from our commissioners?
If I may, Madam Chair.
Yes.
First, I'd like to thank the staff and management for all the work that you guys do. And second, reference to the safety of the inspectors when they go out. I understand that you guys were sworn into part of the enforcement group, just to be clear, like for the inspectors to go out and inspect on properties that are commercial, residential, or agriculture?
No swearing in. So we have a compliance section that did not swear into any type of.
I see. And then perhaps maybe when the vehicles that go out, are they equipped with maybe yellow, amber flashing lights or badges?
No, the
that they
employees
found
have badges.
From CHamoru Land Trust?
Also decals on the side of the doors.
That's all. So then the second item was the Guam Housing Corporation. And I understand that the last time we had a memorandum of understanding between USDA, Guam Housing, and CHamoru Land Trust. That's been ratified. So what's our status on that?
I'll follow up with the new MOU.
Okay. And that's the memorandum of understanding for, was it 5 million?
I believe
Oh.
it was 500,000
500,000.
for a revolving fund.
Okay, got it. Then the last item would be civil case 17, that's the Fair Housing Act. So that's the report that Attorney Miller is going to be submitting.
We'll be submitting to him.
Okay. And then resolution. Oh, okay. Lot 5173-1-R2-6. People Point or
Oka Point.
Oka Point?
Yeah,
What is the
they're-
size? What's the size?
I believe the remainder is about 28 or 24. I'm not
24
sure.
acres?
Yeah.
And then there was another lot, 5173,
Dash 1, dash R2,
Dash one,
new
dash-
dash 6.
R2-6. That's the second. And what was the first one?
5173 dash 1 dash R2 new dash R7.
R2 new dash R7?
Correct.
Okay. Is that where the cultural center in the Northern Maninaca is located?
It's within there.
Okay. So total area is about 50 acres or so?
I believe prior to the delineation of, or surveying out the second Katulan Chamorro, and the map plan, I believe it was like 48.
Okay.
I'm
And
not
the
sure.
bill has been submitted already to Committee on Rules? I mean, do we have the bill? Well,
We have a copy, we'll provide everybody a copy.
It is with the rules committee.
Okay, so. I'd like to make a motion for maybe the Attorney General to perform a complete abstract and PTR on these two particular property, just to verify that the property is under the inventory of CHamoru Land Trust and that it's free and clear without any encumbrances. Just to verify.
I think we can perform that as a
Or,
request or.
yeah, just an abstract and a chain of title from the beginning and to the present, present date today.
We have something.
Okay?
We can provide that.
And then,
Your time limit.
well, I got two more, but go ahead.
We can come back to you.
Would you like a copy before?
Please. Got two more major items, but
Five.
Yeah, we can come back to you. Next, do we have the court reporter?
Yes, the court report is present.
Madam Chair,
Are we still in the director's report?
That's
If
fine.
you have any questions, he completed it, but if you have questions, go ahead.
Thank you, Acting Director, Mr. Cruz, on your director's report. Couple of things, if I may. Maybe possible in future reports that will be written with your submissions of supporting documents within the report itself. Therefore, we haven't actually put the document in there so we can see exactly what the report is, so that every month we'll be reporting on what's passed and then what's cleared out and what your progress is moving forward. The next one, Madam Chair, Acting Director did bring a good point up in terms of the COT's position, in terms of vice chair, chair. What I do know is that we do have one pending vacancy, and I'm not too sure how that vacancy will be filled. And I think we have a total members of 5 total, and we're lacking one more. Is there a process in place to find a 5th? But we are a governing board, so we can actually make a recommendation, right? What's the process?
ultimately, you all are nominated by the governor, confirmed by the Guam legislature. I'm sure the governor would invite suggestions if you all individually or collectively want to make a suggestion. And at the same time, I know she's got folks looking for board members all the time. So however you all want to try and help one another out in finding that 5th member.
Yeah.
The vacancy, it's my understanding the vacancy has to be a female. The board's supposed to be composed of two women and 3 males.
I believe there's something like that in the GCA
Yeah.
that if there's a board of 5, there has to be 2 females in the board.
2 males or vice versa.
But we'll look for that section and we'll provide it, just so that we have something to reference.
And then he does bring up another point of creating your sergeant arms and your vice chair within the commissioner's side. The other thing there that Acting Commissioner, Acting Director, Mr. Cruz, you did bring a good point up in your subcommittees. That is a very good project position that each of us as commissioners are tasked in certain, whether it be the commercial side, the residential, the leases, so therefore we have the ability to work closely with COTs, Acting Director Cruz and his staff, and then report on the findings within our meeting, and it becomes an agenda driven where the decisions are made, so that it moves quickly in terms of decision wise.
Okay.
So in the interim, we don't have a vice chair. Can we motion to establish a vice chair versus other groups?
That, Madam Chair, members, that would be entirely up to you all. Now you want to take up this question, or at the next meeting, you want us to formally put it on the agenda, it's entirely up to you.
Take it at the next meeting.
The next one, and my last one, Madam Chair, is that it was brought up in our director's report about the return of the lands up at Depot Point. But, knowing that, I make a motion that we have a 30-minute look at the legality of what was the initial intent. And we're at this point where we're now at the point where it's a recommendation by the governor to return it back to the village. We want to see exactly the transparency of what was the original intent and how it is now. I know there's quite a few concerns out there, but just want to make sure that we have the legality as a formal opinion of what can be done.
Yeah, he'll look into the agreement.
Yeah, when we put together the chain of title for you, we'll, be sure and review those deeds and see whatever covenants or conditions were written into the various deeds from the parties through the chain of title.
If I may, Madam
What effect would that have if it went into to the Rules Committee of the Legislature? How would that affect in terms of knowing that this is CLT's property, and then us going to the Legislature? How does that process work?
Very generally speaking, not about this particular piece of property at all. If as a grantor, if as the owner of the property, when you convey your property to a buyer, to a grantee, if you write into that deed conditions that the grantee must adhere to as to how they're going to use the property, and you include language which says, and if you don't use the property for these conditions, then this or that happens. Those conditions, when the grantee accepts the property, they accept the property subject to those conditions, and those conditions generally, as they say, run with the land, which means the everybody else later in time must follow the same conditions. And so, just to give you a couple of different examples, if as a property owner, I gave my property and said it has to be used for the benefit of the people of Guam, I could imagine many things that would meet that condition. On the other hand, if I conveyed my property and said, this property must be used for a school, and it must be used for a school for, children in kindergarten to the 8th grade. If you're that specific, you can't, you can't build a government office building on that property. Can't even build a high school on that property. You must use it for exactly the specified conditions. So in in any evaluation of what the obligations are that run with that property, you have to read the deed that creates the original conditions and evaluate whether, how specific those conditions were, and is today's use of property, does it meet up with those conditions? I will say, you know, there are situations where somebody wrote into the deed, you know, the conditions that, you know, this property must be used as a pasture for all the, you know, retired horses that the government of Guam used for pulling its carts around the island. Well, if that's the deed condition, you can go to court and say, Your Honor, you know, we don't do that anymore. Nobody does that anymore. And you know, we want to do this other thing. And the judge would probably say, yeah, you're right. You know, that condition is now impossible because the world has changed sufficiently. But in the absence of a situation as dramatic as that, the law is quite clear that if there is a condition on the land that runs with the land, everybody down the line has to live up to that rule.
Now, all of this will be based upon your review. You may know all of that within the review of these two properties that you're.
Absolutely, and you know.
Your request, Commissioner Ibanez, he will report back to us.
Yes.
So without further questions.
Well,
If I may.
FYI, since you're going to be doing that historical search on the property, I spoke a few years back with the son of Frank D. Harris, who deeded the property to Guam, and it was with the caveat that it would be used for a hospital, and also in exchange that the Guam at that time, this was post-war, Guam at that time would provide him with, let's say, 2 dump trucks or something like a heavy equipment. And according to Mr. Greg Paris, they never got the heavy equipment. But I don't know if there were any stipulations after that, because Guam did meet part of its obligations. They did build a hospital there. I don't know if after building the hospital, are they required to maintain the hospital or rebuild a new hospital? I don't know. I leave that to you.
And again, generally speaking, the governor's free to propose this legislation, the legislature's free to take up the legislation. It's really up to the heirs of Mr. Perez to say, no, you know, my family made this deal with the government, and now the government's welching on the deal, and it's, generally speaking, it's up to that original landowner or the heirs of the original landowner to put their hand up and say, nope, that's not the deal. And if you want to do that, then as the deed says, generally speaking, what the deed will say is either we get the land back, or the land goes to this guy, or there needs to be some language in there which says what happens if a future landowner doesn't adhere to the deal. But it would really be up to the Perez heirs to decide if they want to try and enforce that condition.
Thank you.
May I, Madam Chair? If I may ask the administrative director, acting administrative director, to pull out the minutes for January 2016. And then, based on the testimony provided by Senora Margarita Perez, indicated on that minutes that this is the daughter of Frankie, that the property was sold to the government. That's number one. Number two, I would like to respectfully ask the Attorney General, the Assistant Attorney General, to request the AG to provide an official, opinion on the specific property. Because, case in point, during the return of lands to the Tizan property, a lot of the Tizan property owners had their property that was within the runway and in the jetway and the taxiway area. So they sued the government, but just to verify the position on this one, at that time the court ruled that once the federal government was that transferred the property to ancestral lands or land trust, that the court ruled that the legislature cannot just inadvertently the property from that inventory out from the inventory of the ancestral lands or land trust, but just to verify and to provide us an official opinion from the Attorney General, Doc Morgan. So the reference again, the minutes of that reference, you got it?
Can you just repeat that, please?
Will be January 19, 2016, and that was a testimony provided by Senora Margarita Perez. And documented and verified by Governor Carlton Skinner at that time. So do we need a resolution to request for that, or that would be?
I think you
We're good.
Got it?
I'm taking note.
Okay, so that's in reference to the bill. Actually, there's no bill number yet for the transfer of lot 5173-1. That's R2-6. Okay.
Are we gonna go into executive session?
Madam Chair, members, if I can, just give you a brief introduction to executive sessions. We will need a motion, a second, and a vote to go into executive session. In that motion, it would be helpful if the motion were to include a reference that the purpose of the executive session is as set forth at 5 GCA section 8111A. If we could make sure we get that reference into the minutes. And just so we're all clear, and everybody in the audience and everybody on TV is clear, the purpose of the executive session is essentially to give the commission and Mr. Gamboa the opportunity to undertake what amounts to a job interview. What we can't do in executive session is make any decisions. It's an opportunity with the doors closed and the TV cameras off and the public out of the room for you all to engage in whatever dialogue is you all consider necessary and appropriate to consider whether this is an appropriate individual to serve as your administrative director. But again, we don't make any decisions. Whenever the time comes that you wish to make a decision, we will have to put that on an agenda, and it's not on today's agenda. So we will have to put on the agenda, a notice that the board will consider offering the position of executive director to Mr. Gamboa, and you know, that will take a, you know, a motion, a second, and a vote in a public session. So, again, if you're ready to go with this item, we need, as I said, we need a motion and a second. And as soon as, assuming that will pass, it'll take us a couple minutes to clear the room and turn the TV cameras off, and then we'll start.
I'm sure may I ask, prior to us going to executive session, is this a, just to get a clarification of the duties of our position of commissioners, this is a governing body itself, so we can take the nominee that was nominated and make a decision, but when you open up the decision, can you, before you do the executive session, can we see it open to public before we even do any executive sessions? I'm just curious what the process is, because I'm fairly new, but I see we have executive sessions, and I think it would be incumbent of us to look at everybody as a whole versus just one individual, although it's a nominee from the government. I just want to get some clarifications into the process of.
Madam Chair, members, I honestly don't know whether, you know, this is a position where, you know, in theory, you could put an ad in the paper and ask for people to send you applications or not.
Are we able to, before we even decide, are we able to get confirmation via, as you as the legal counsel, to get a clear understanding of
Sure.
our role, so that we can make a thorough decision to what CLT's mandate is and what our governing body does?
Fortunately, Director Cruz happens to have a copy of the relevant statute here, yeah, which says, you know, the commission shall employ, it's the commission, shall employ an administrative director who shall serve in a full-time commission and shall exercise powers and authority as it's delegated to them by you. So if your, you know, if your preference would be to, you know.
Madam Chair, with that set, after consideration, the current nominee in the position of Director of the CHamoru Land Trust Commission, I recognize the importance of ensuring that the individual chosen for this critical role possesses the necessary qualifications, the vision, and the commitment to uphold our missions and serve our beneficiaries effectively. To this end, I understand that we do accept the governor's nominee for consideration, and based on our attorney Miller reviewing the mandate as provided by Acting Director Mr. Cruz for consideration, I believe it's in the best interest, Madam Chair, of transparency and fairness to open the position to all qualified individuals. This approach allows us to ensure that we identify the most suitable candidate to lead the commission during this pivotal time. We, the commissioners of CLTs, remain committed to conducting a thorough and impartial selection process that reflects the values and responsibility entrusted to CLTC and by the people of Guam. We look forward to receiving applications from interested individuals, and this is, again, like I said, the clarification of what was provided provides this insight to us, so that, again, although we do accept the governor's nominee for consideration, I believe would be in the best interest for transparency. So I make a motion that we
Yeah.
So, what Attorney and I were just discussing really briefly was, the board can also still go into executive session. The board has accepted the nomination, not in terms of hiring for employment, but at least discuss it. But not to say that if the board should choose to announce it, we'll still take Mr. Gamboa's nomination and put it with the other packets. But it's up to the board.
In other words, we can go into an executive session as a Q&A.
Yes.
Notwithstanding what board member Ibanez has said, we're not going to make the decision, and as he is expressing an interest to open it up for competitive applicants. That's what you were saying, right?
For transparency, we should, I mean, based on our mandate, based on we as the commissioners who have that authority to make that decision, we should at least open it up and provide the transparency and fairness to the members. I mean, we are the governing board for the people who want to control the land. So we should actually open this up to everybody out there, not just because it was not me. I'm not too sure whether we have Q&As ready for Mr. Gamboa, and if we're in a position to ask these specific questions to the job description as a director itself. But I think we need to be prepared for those types of questions, because once we open it up, we have to have transparency and keep the questions moving along for every single candidate that decides to apply.
So what comes first?
Do we have a copy of the nominant's resume?
Aside from it being emailed, we printed it out. Just-
Madam Chair, members, we, we have noticed for today's meeting the possibility that the board will vote to go into executive session for the purpose of engaging in Q&A with Mr. Gamboa. Today's agenda does not include an agenda item that would cover offering him the job today. So even if you wanted to offer him the job today, you couldn't offer him the job today. If it is the pleasure of the majority of the board to direct staff to post the position and, gather applications and resumes, and, the staff and I do as you all direct. If it is your pleasure today to want to undertake some Q&A with Mr. Gamboa, we have that opportunity. He has requested, it's his choice, he has requested that it be in executive session. So if we're going to do it, it still takes a vote, but at his request, it was made to do this in executive session. Or, if you want to wait until another day when you have more resumes in front of you to even initiate any questions and answers, it is whatever a majority of the board wants to do.
Madam Chair, by me, based on Attorney Miller's guidance, I make a motion that we table the executive session for the Q&A until such time that we have and we allow Acting Director Cruz to prepare the necessary documents for our review, and then we can proceed into the executive session itself. Right now, I don't think we are prepared to, in my opinion, to ask any specific questions in relation to the director's position itself that's being posed. We haven't had a director in quite a while, and Acting Director Cruz has been acting for quite a while. So I make a motion that we table this and we proceed forward in ensuring that we follow the mandate of what COT is mandated to do. I make a motion that there's
You brought up two,
Just a motion to ensure that, like, with the guidance from Attorney Miller, that we allow this acting director Cruz to prepare the necessary documents for our review. Because once we go into executive sessions, we have the necessary information in front of us. But I guess it's time to prepare all the necessary documents for, based on our mandate, to put it out for, this provides, again, this is just to reiterate, just so that everybody's aware, is that, while we accept the governor's nominee for consideration, I believe it would be in the best interest of transparency and fairness to open the position to all qualified individuals. This approach allows us to ensure that we identify the most suitable candidate to lead the commission during this pivotal time. And we have a lot of agenda for our residential site, so it's only fair.
okay,
Madam Chair, members, if Commissioner Ibanez, if I could make a suggestion, if you could divide your motion into at least two. One motion is simply to table agenda item number 5, and then we'll, assuming that gets a second, we'll vote that one. And then the next motion I would expect you'd want to make is to direct staff to prepare, an appropriate job description and advertising and, what do you want staff to do to try and round up more candidates?
First motion is to table the executive session. I make a motion to table the executive session for the, based on our agenda item number 5. Pursuant to 5 GCA section 8(11)(8) on the nomination of Mr. Roy Gamora to serve as the administrative director, is to table the executive session on our agenda.
I second the motion, Madam Chair, in addition to the second motion.
we have to do one motion at a
The
time.
second motion is to,
Wait,
Wait,
So now we're gonna vote, the motion to table.
I have a question for discussion. Point of discussion, Madam Chair.
yes,
Mr. Cruz, you had to engage the services of a court reporter.
Right.
Is there a minimum time limit for the court reporting?
I believe it's a lot type charging, so for the 4 hours is, I
So
believe,
minimum is 4 hours, is that what you're saying?
they're gonna charge us for 4 hours.
And how much do we pay for 4 hours?
So if I remember correctly, the quote is about $380 some. That's just the presence, and then there's a lock and key type fee, which the court reporter will have to keep it sealed for 6 months. And then there's the transcribing, which is about $1,200. So it comes up to roughly about almost $2,000 if we were to,
Abort.
to start
accept the services of the court
the
reporter.
court report.
In essence, we haven't started. The executive session didn't go into place.
No, but we've already engaged her services or his services, have we not?
I don't, the court reporter's present, and he can clearly answer the question. But that's the quotation we got if his services were rendered.
Feel free to ask him if he does nothing today, what do we owe his company?
Who is the court reporter?
The gentleman in the back. I believe there's an appearance fee. I think that's what it's called. Sir, if you don't mind coming to the table. Can you stand up?
Yeah, we have to sign. We have to sign. Oh, sign. Oh.
For today, the executive session is canceled. It suggests the appearance fee of $395, but then there's a 20-page minimum, because we're here to produce documents, and if it's not produced, then there's a minimum of 20 page
So what this basically tells us is that we, as commissioners, should be well informed of the fact that there should have been from the acting director letting us know that we're going to be going into executive session aside from this going out to the agenda itself. So with that said, we still got to make sure that we provide the fairness based on our mandate. I understand there is a cost itself, but bottom line, it should have been incumbent upon our acting director to provide that information ahead of time to us, so that we prepare for this executive session.
There's a motion and a second, we'll need a vote, unless there's more discussion.
All in favor, say aye.
Aye.
Motion carried. Second,
Second motion,
All opposed?
anyone opposed? One
Aye.
opposed. Aye, yes,
I oppose.
I oppose. Nay. Go.
the second motion is to, with the guidance of Attorney Miller, provide the guidance for the position to be opened up. Following Guam's law, the administrative HRs, ensuring that we follow the proper employment process that needs to be done. And will provide the opportunity to prepare job descriptions, to prepare everything that's necessary to put this out to you. Again, just to make this very clear, yes, we understand and we do accept the governor's nominee for consideration. And I can't emphasize that. I mean, we do accept the nominee, but based on CLP's mandate and what Attorney Miller has just provided to us, is that we must provide the interest of transparency and fairness and open the position out to all qualified individuals. This allows us to ensure that we do have identified the most qualified and suitable candidate to lead the commission during this pivotal time. So just for clarity purposes, so everybody knows.
That motion will need a second.
Was that motion including position description
Everything,
and the questions to be formulated so that all questions are applied to every candidate?
That's a
I can amend that.
completely our preference would be that the next motion simply be limited to directing staff to do what is customarily done to advertise a vacant position. If you can certainly take it up now, or you can take it up at a later meeting, what process the board wants to follow to evaluate potential candidates. But it would be helpful if we just limited the second motion to do the standard things that we do to advertise a vacant position.
So that motion's in place.
So formulating the question would be another motion?
Yes.
Yes. So we need a second on my motion.
So this motion is for position description, a complete comprehensive.
Advertise the vacant position the way we would advertise any other position.
Second.
All in favor, say aye.
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 If I may, because when we did inquire with the Department of Administration, there is no specific job specs for the administrative director position. So what we did go ahead and do is start extracting where there is such a position, a classified position, and what we will do is we will take that information, compile it with other information for similar positions. We will share it with Attorney Miller and also each individual board member individually. If you guys would like to amend, change, or anything like that, we'll take in those recommendations until we get a final product, and then we'll present it to the board.
I think the best process would be, since we have our legal counsel here, to be able to guide you into providing that. And ensuring that it does fall within that job position, JD itself.
Motion carried.
We would like to say names.
All in favor?
There's no names.
Madam Chair, if we can take a 5-minute recess, Mr. Gamboa is present. It would be so that I inform him, even though he heard it already, what's happening, and extend the professionalism and courtesy to Mr. Gamboa. So if the board can consider taking a 5-minute recess.
Sure. 5 minutes. We're back in session. New business. The Guam International Country Club.
Madam Chair, if I may, the statements in your packet have been updated. Unfortunately, we did an internal audit and discovered that 1 month, December 2023, was not invoiced. We went back and corrected it. So I'm passing out new statements and open balance statements and a breakdown of what payments apply to what invoices. So this would supersede what's in the packet. And there's a breakdown of what payments apply to.
That replaces which one?
Both. Thank you. Present today for GICC is Mr. Yomi and
Jerry.
Jerry, Mr. Jerry.
Dark Cruz, I think Carlos Camacho is
Online.
chiming in on.
Sir, can you pull up the? Mr. Camacho's present online also. So to proceed, if Mr. Yomi and Mr. Jerry can just please sign it. Today, GICC is on the agenda as a result of the last month's meeting, or the November 21st board meeting, where the board had voted and motioned the non-compliance of GICC, non-compliance of lease terms 4 and 17. Mr. Dexter Tan was supposed to give this report. This is his report, but I'll go ahead and provide the summary of his report. The Guam International Country Club is in compliance with their payment plan that was approved by the previous board. To date, GICC has a receivable balance of $414,526.12. Although the condition of the leased property continues to be a concern due to the overgrown grass and vegetation and the abandoned like-looking warehouse, which is not conducive to the purpose of the leased property, which is to construct and manage a municipal health facility. Furthermore, there exist about 4 more hens that have made the ponds their habitat. We've done several site inspections of GICC, and the overgrown grass just continues. It doesn't show of any type of golfing activity that's occurring, which is the initial or the main purpose of the lease that was awarded to Guam International Country Club. Madam Chair, Commissioners, that's the report that was prepared by Mr. Tan.
So,
Director Cruz, can I get a copy of the spreadsheet? Okay,
Yes.
thank you.
There's the account statement.
Yes. Thank you.
it's double-sided, so
Madam Chair, members, really the purpose of today's agenda item is for you to ask these fellows any questions you might have about the current status of your land, including the specific issues raised in the notice of noncompliance, and then based on what you hear today, as with any agenda item, you can choose to do nothing, and we'll just continue monitoring the situation at the country club until you direct us to do something else, or you have the opportunity to direct staff to take a new course of action with regard your property. So, how you all want to proceed in terms of understanding what your lessee is up to is entirely up to you all.
I'd like to, if I can, get everybody up to speed on, what's been going on. Commissioners, I see a lot of familiar faces, so Happy New Year. It's good to see everybody, Director Cruz. Let's say legal counsel, good to see you. Let's say I see a new face. Let's say Commissioner Bannis, welcome. And I want to take this opportunity to thank you for giving us a chance to appear. And then let's say I apologize in November. I understand that there was a meeting that we missed. I think people were off island, and then I think Carlos is calling in because he's still off island, no medical. And then, we've all worked together very hard over the past couple of years to find a viable income stream from this property in order to support the mandate, the mission of the Toronto Land Trust. And we still stand here today fully committed to financing, to funding what was agreed to. And as you know, last year, we appeared at a public hearing before the legislature to support Bill 179-37. And speaking to the sponsors of the legislation, we have the support of the legislature. But for technical reasons, and also because as we hit the holidays, the bill was never introduced to the floor for a vote. Something about it, being in committee. Since then, of course, we've had an election, and based on our discussions with the sponsors of the bill, I think our position is even stronger. In the interim, I know a lot has happened. There's always, because the opponents of this, there are strong opponents of this bill who are advocating to keep the golf course a golf course, and they don't have any. I'd like to add that they haven't put any evidence to support that it's viable, because as we all know, our tourist arrivals of Guam right now are still less than 50% of pre-COVID. And there are golf courses that continue to go out of business. These are for-profit golf courses. They're losing $500,000 to $1 million a year. In fact, the onward courses, Manila and Telefofo, are sales pending. Last year, Starts was sold. Winter Hills is closed. So there's no, and that's the business aspect side. But in terms of I'd like to address certain things that there was a certain, misunderstanding, misinformation that's been circulating. And one, Commissioner Bannis, I want to get you up to speed is because, these things take time, and so there was a payment plan. JCC is on a payment plan, and JCC has been in compliance with the payment plan for the arrears that it fell behind during COVID. Because JCC did not qualify for the federal programs like the PPP, the loans that were made available to U.S.-owned companies. So JCC had requested for some type of relief, and time when Angela Camacho was the administrator, there was a payment plan that was agreed to. So Director Cruz, if I need to. So according to this letter that memorializes the payment plan, GSCC has been in compliance and they've been paying the regular rent plus catching up on the arrear rent. And they are on course, it says requires that all the arrear rents be paid by October 2026, and they continue to make payments towards the regular rent and the arrears. So I'd like to just clarify that. And then I'd also like to clarify one other matter is that there's been some allegations that we're not cooperating, that GICC is not cooperating with the Department of Agriculture, and that is completely just not true. What we are concerned about is whether or not these are official acts of the Department of Agriculture, because this was addressed back then in a letter dated June 27th to the for Land Trust, the Commissioner. I don't want this to count against my 3 minutes, so maybe you can take it again first.
The board members had received that.
So anyway, this letter was sent to the commissioners on June 27th of last year, and this was soon after Mr. Russo, I think it was you brought the members of some biologists from the Department of Agriculture to do inspection at the GICC golf course. And our concern at that time was because of the email chain that is attached to this letter. We were very concerned that Russell was misrepresenting that he was speaking on behalf, he was a representative, authorized representative of JCC, and he made arrangements with the Department of Agriculture to do this inspection. And that's exactly what the email chain says, right? Because the biologist Megan Bolstead was emailing Mr. Young, trying to set up a time. To do the inspection. And Mr. Young's response to Mr. Russell, to Russell was, hey, just have the Department of Agriculture contact us directly. And we did reach out to Department of Agriculture. We weren't passive about it. So this exact same letter, if I can circulate this one.
Here you go.
There's something for everyone, yeah. So, we reached out to Department of Agriculture, we make sure that Director Munia, had a copy of this letter too. And and the thing is, of course we're gonna comply with whatever development regulations are from, not just from Department of Agriculture, but during the course of development, when you're going to get a building permit, you're just going to be all these agencies that's going to sign off on it, and then one of them will, in this case, would be Department of Agriculture. And I want to clarify also that the third thing that I'd like to point out is that the bill that was introduced, 179-37, right, was completely based on these are public records, you could compare it. The bill that was brought before the legislature is based off of the Land Trust's resolution. So I think that's part of the record here, so I won't make that, I won't submit that, but And when the board members have time, or the director, right, you could compare it to the bill. We've always acted in good faith. We're not trying to pull a fast one. We never try to mislead anybody. So we make every precaution to make sure that the bill actually reflects the resolution that was passed by this body. And so, that's part of the public record. And I think if there's any confusion about allegations about swapping bills, that's, I think what you're referring to is initially, as I think the commission might recall, was I had this great idea that we're gonna do an endowment fund. And we're gonna put the $9 million in an endowment fund, and then and then Chamorro Ranchos will have a perpetual source of income where only the interest was going to be usable, and then the principal will continue to be a third stream of revenue forever. But I think the commissioners didn't like the idea, so, and it wasn't adopted, right? So we didn't do that. And then, so that's the three things that I like to point out. And finally, what is not part of the record over here that I like to, make part of the record is that I'd like to share this with the commissioners. I'd like the commissioners to know that your hard work is not unrecognized, and the people of Guam, the vast majority of people of Guam support your mission, support what you're trying to do, to right the injustices, and what we're trying, to do what's right for the island. And what I'm sharing with you is a resolution by the Delano Municipal Planning Council that voted in favor of Bill 179-37. And over several days of public hearings, we heard testimony from people talking about why they support it, and the reasons why they support it remain the same. Nothing. It's 2025 now, but there are certain things that remain the same. Chamorro Land Trust is still short of funds. Chamorro Land Trust properties are still short of infrastructure. Power rates are still unaffordable. What's different though is we're out of COVID money to hand out to lower our power rates. And so this proposal to convert the GICC to a solar power plant will address those concerns of the power rates of everybody on Guam. But more importantly, it will infuse money to the Chamorro Land Trust Commission so that it could do what it needs to do with that money for infrastructure improvements. I think I should yield to Carlos. I'm sure he has more things to say.
Carlos is a representative of GICC, or?
Yes.
Yeah, can you guys hear me?
Yes.
Yes.
Madam Chair, Board of Directors, Attorney Miller, Acting Director Cruz, thank you. Like Jerry described, we've been doing this for 2 years. We've been going through all your public hearings, legislative public hearing, when we're trying to go into Bill 179. I just want to make it very clear that when I got engaged to advise GICC, it was the original intent to find out what can we do to economically make the property viable. And as Jerry described, after COVID-19, we did submit a letter in April submitting, we first thought we were going to ask for a reprieve on our arrears, but the statute does not allow that. And that's why the board at that time came back and said we only can honor a payment plan. And it was at that one board meeting, board member Burrito, who suggested that we'll give you a 3 months probationary period. I want to make that very clear, probationary period. If you guys were behind or made any late payment after we granted you this payment plan, then we will do some action on behalf of CHC to do what needs to be done to recover any of our arrears funds and delayed payments. So as Jerry described, from that day forward today, and what Mr. Director Cruz has mentioned, that we've been in compliance and paying on the arrears, and in parallel to that, we've been in compliance paying the regular rent. And yes, Commissioner Urbanis, from one of the quotes you did in the news, you were correct. Why was there 2 different bills? I want to explain that real quick as Jerry described. The first bill included an endowment foundation, which the money still goes to the land trust. The only reason we suggested that endowment foundation approach is history has shown that legislative bodies, not this, and previous governors in the past, took money out of CHamoru land trust when the government coffers were hurting of financial resources. And if I'm not mistaken, one of the good examples, they took some money in the past, many governors ago, and they never, I'm not sure they replenished some of you guys' account. That last I heard in the last 2 years. So we wanted to make sure that the $9 million that was suggested based on the net present value of the rental cash flow is protected and nobody can touch it. But at that time, Acting Director Birch and the board did not want to freeze up that money, they wanted flexibility. So later, the board passed a resolution with all their needs and wants. And one of the things they did that resolution is, number one, requested by Chairwoman Bernalio, that we must meet all regulatory permitting agency. That's EPA, DPW, Department of Ag, all the agencies that are involved in any projects in Guam. Second, we made it very clear that we will use PFAS-free panels. Because one of the concerns that third parties were concerned about was the potential environmental concern on our northern water drinking lands, which we will assume EPA and the US EPA will either approve our project or not, once they look at our panels or equipment that we're using up in the site. Finally, one of the needs and wants, and you guys saw that in your resolution, was asking for the clubhouse for future office for CHamoru Land Trust and other land agencies you guys wanted to offer. We agreed to that in that second amended substitute bill. We agreed to that. That was the request from CHamoru Land Trust. And finally, in the event bill passes, that we immediately within 30 days pay up any arrears that GACC owes to CHamoru Land Trust. All those concerns were built in the second amended 179-37 as substituted. As Gary described, during the October-November session, because I'm still in Arizona for medical reason, we got all the resolutions from CHamoru Land Trust throughout the term, Guadalupe Municipal Council, and we were just waiting for us to get it to the voting file of the legislature. It never happened. It never made it through the legislature for its final journey to either say yay or nay. We never had that opportunity. But during that debate, when there was some small debate in the legislature, they mentioned a few things. I'm going to say this for the public record. They mentioned a few things. And it's stated by the former speaker in some of her comments, with due respect, when she was chairwoman of land, that CHamoru Land Trust is very limited on funding to fund its infrastructure. The leases it's been giving out since 1995. As we all know, there are those families got leases that benefit because there are utilities close by, and there are families, like example, the Uman development in Agate, 219 families were given the lease, which was done, they got the lease, but no infrastructure. 20 years later, they do not have the infrastructure. So this is why we're not selling the property for good, like you guys just described earlier on another community property. This property is just a lease. We're just asking the legislature for an additional 17-year term to extend our lease 17 more years. We need legislative approval for that. And it was the legislature that developed the municipal golf course. So we needed the legislature also to change the use from a golf course to a solar farm. We're doing everything up and up. We're doing everything through public hearing process. And we don't know if we're gonna get the votes or not when we're doing 179. But that didn't happen. Just to give you guys a heads up, fortunately, the sponsor of that bill, Senator Joseph Augustine, is willing to reintroduce the bill on the 30th legislature and taking all the consideration that was discussed during the last bill that was not included in the bill. Like number one, in the last meeting that we were not there were concerns from some indigenous group that there are some indigenous plants, aphid trees, some indigenous recognized plants. For sure, we will not demolish those plants. And I, as an advisor to JCC and as a developer developing homes in Guam, I comply with all regulatory agencies, especially Department of Parks and Rec and Ag, to make sure we comply with all permitting. And if there's any things related to endangered plants and trees, that will be part of the permitting process and to be protected as states in statute. In regards to the fish and wildlife and the moorhen birds that you guys heard from Mr. Cruz, there's 5. There are fish and wildlife remedy and solutions that's being adopted right now on what needs to be done to protect these endangered species. We will follow every spirit of law as stated in your resolution. But to make it more clear, if a bill is going to be introduced on the 38th, we will fully clarify that we will comply with any government of Guam and federal fish and wildlife permitting compliance. We want to make sure that's mentioned. And in regards to the non-compliance that our grass is growing, that we were not complying of putting a golf course, I wanted to just go back to the small history in 2 years. When we had the resolution of CHamoru Land Trust, when we had the resolution of the Federal Municipal Council, we assumed that we will get the votes from the legislative process. That did not happen. So we, after 2 years of going through this whole event, that did not happen. So we are going to now incorporate all the other concerns that was, as I discussed 5 minutes ago. Hopefully this new proposed legislation, if they introduce it, and if not, then we can talk and see what our next steps are going to be in regards to our existing lease. So I hope that I could, what I just gave you is a little chronology and history on the process. And we, again, appreciate the time and opportunity of speaking. And I'm sorry I got a circle there, it's at 42 degrees. I'm in Attorney Miller State right now in Arizona, where he came from. So it is very cold today. Thank you very much for allowing me to speak.
You're welcome.
Thank you.
thoughts, Commissioner?
Question, Madam Chair.
Yeah.
Now that we're at this stage, maybe to Mr. Jerry and Mr. Yoder, so, what are your plans right now? Because right now, Bill 179-37 is moved on. So between now and tomorrow,
I think what's necessary is because there's I think we need to present to the commissioners, the plan, right? And I think in terms of what Carlos was mentioning is we want to make sure that that the commissioners are supportive of the plan. So before we introduce any new legislation, we want to make sure that we present the details of the plan to the commissioners to let them know, to make sure that we're supportive and to get your support before we move forward, and make sure that that commissioners have an opportunity to improve the plan. And so a couple of things that I think that we want to explain to the commissioner, how our thoughts on improving the plan is going through that process was not completely unproductive, because I think that what we need to do is explain more on the valuation of the property. I know the original plan was, okay, the Toronto Naturals will get its own appraiser, right? And then and I think that's still a very good plan, but I think when we did the analysis, we did a net present value of the future rental stream, right? But then I think it was brought to our attention that during the extended term, instead of just running that same, like a rent escalation under the lease agreement, right, or the extended term, right, that we should get a completely new valuation for that extended term that's not covered by the lease agreement. Because what we did was, originally to calculate net present value, we took the current lease, its rent escalation clause, extended it out, increased the rent escalation so that it's a more favorable result. But then what was brought to our attention that, hey, you know what, for the time period that's outside the current lease term, right, you should get the appraiser should have a free hand on appraising that value. So I think that's one improvement that we want to do. And then the other improvement that, I think that would yield better results. And then the other one that I'd like to have the commissioners think about is, we really like the idea of having the commissioners have the control interest, to have the freedom to use their judgment on how to apply the advanced accelerated rent that it collects. But it has also been suggested to us that there are certain identified lots, like maybe a couple of hundred, identified lots that has been leased out that needs infrastructure right away. And so it's also been suggested to us that, hey, maybe we put that in the bill, that, hey, you know what, let's make sure something is done, because, these people have been waiting for so long. Let's specifically earmark, those funds for infrastructure for these lots. But that's something that that those are just ideas, and I don't think that we will be able to address, those discussions in this one meeting. But what I will do is put on ink and paper and provide that to Director Cruz, to Attorney Miller, and then to circulate amongst the commissioners, so that it's something solid, something detailed for the commissioners to consider. But 100%, that we will not be moving forward with proposing any type of legislation without first consulting the commissioners and making sure that it's consistent with the control land transmission and the best interests of the beneficiaries.
Jerry, board members, can I add just 2 more minutes of my speech?
Go ahead.
Okay. Thank you, Jerry. During this process, we did learn one of the projects that CHamoru has tried to do ever since the Calvo administration. They tried to do this project in Chico. I don't know the lot number across the gym, but so known, because it's been stated in the legislature, as known as Project 166. It's 166 lots. So give a little history about that, Commissioners, for those that know about it, and the new one there that Mr. Evans that came in. Project 166 was 166 lots fronting Marine Drive. Water, power, and sewer cut right to the property to service Paradise Meadows. Agency review committee was done, rezoning was done, but at that time, during that governor's term, it never moved forward because they did not have access to the funds to develop the property. Then when Governor Liu came in and her term, in February 2022, they took the same property under the director of Angela Camacho and advised by Mr. Joey Cruz. They went to DPW and they ran an ad to request for interest. Anybody interested in developing the 166 lots? 5 potential proponents applied, but remember, that's request for interest, and then it's supposed to convert to an RFP from that point. But that never happened because we found out, again, it never moved forward due to lack of funds to move forward for an RFP. Once you put an RFP, you gotta identify the funding source. So, 2 governors before that, Governor Carl Gutierrez, that was going for 8 years, that what he did was, yes, he did sign leases after the hard battle, Senator Angel Santos, through the Ad administration. Governor Gutierrez finally signed leases, but what he did was incorporated a second financing arm for CHamoru Land Trust, which I got involved in that way back, called the Native American Loan Program. Today, that's one of the second financing program that Guam Housing is administering for Native veterans with CHamoru Land Trust. And if I'm not mistaken, Joey can confirm that. I think we did 12 or 24 of those loans with Guam Housing to the Native veterans. And the other loan, as I described, was Guam Housing loan that Joey described earlier. And the second governor, Governor Camacho, came in his term and adopted the 2005 MOU. The 2005 MOU, which is with USDA, which is the one you guys are adopting today, the second version. That never happened because there was a Fair Housing Act lawsuit for equal housing opportunity, and that one stopped that triggered that program to kick in. That was already signed by CHamoru Land Trust and Guam Housing, but that lawsuit stopped it until it was resolved in the tail end of the Calvo administration, and finally the legislature passed the correct policy to start signing up leases that doesn't violate the Fair Housing Act. So I just want to show the record that the Project 166 that you guys supported never was able to move forward with the infrastructure, lacked the funds. So hopefully, if this bill 179 that was then passed in the 37th, and a new bill gets proposed, and it does pass, and you guys do have the seed money, and like Jerry described, we can put more teeth into protecting those funds to make sure it is identified strictly for the infrastructure, water and sewer section of the statute of CHamoru Land Trust. That way, no legislature, no governor can take that money out and use it for other resources as they've done in the past. So we want to put more teeth to it. We want to make your mission and goal become more accomplished. And finally, at the end, if this was granted, this additional 17 years, at the end of 30 years, the land goes back to CHamoru Land Trust. Again, it's not sold, we're just leasing it for additional 17 more years. So the land still belongs to CHamoru Land Trust, and after 30 years, you guys do what you want with the infrastructure built in, that's connected to GPA, and generate additional revenue after 30 years. So it's not just raw land, and it'll be raw land again after that. So thank you again for allowing me to clarify some of my points on some of the proposed infrastructure programs that you guys tried in the past. Thank you very much.
Point of information, Madam Chair.
Go ahead.
Very short, 2 minutes, yeah?
3.
Okay. So when I got on board in 2022, my first contact was with Mr. Joey. So this lot 166 came into the radar. So I asked Joey what was the status of that property. So he shared with me that he did a RFEI with Department DPW. So I met with Ms. Ibanez over at DPW, and she gave me a briefing. I went through the whole process of RFEI. It went through the 7 agencies. It went through the zoning process and the public hearing at Chigu.
Correct.
So, again, the subject on that issues that there was no fundings again for infrastructure. So the object was to have a public-private partnership, no operation. So fast forward to today. What we found out is that that 166 lots was available, yet we had a problem with number 6 that was in line. We were stuck at number 6. There was like maybe 8,000 applicants, and at that time I discovered that there was like 2,800 leases that were ratified. So far so good. So my question is that how was it that the CHamoru Land Trust was stuck at applicant number 6? Because the applicant number 6 designated a successor that was the grandchild, and we cannot move to number 7, 8, 9 on forward with the 8,000 applicants. And the question there I had was that how did we ratify 2,000 plus leases when we were stuck at number 6? So we resolved that issue with the 37th legislature. We amended the language of having a successor, included as a grandchild, and Attorney Miller was helping us in that language. So Speaker Teresa Lahi introduced the bill, it went through the process, it was passed, so then we resolved that. One of the several issues that were involved with this one, then we got into the clouds with the Attorney General. And the clouds was that how did you pass number 6 and you had 2,800 leases? So then we resolved that again by the help of Attorney Miller with the language that he came up, and we're working on that now. Then the third one, the third issue that we had was what fundings are we gonna provide, even if we had the MOU for Guam housing, the veterans that can apply, we still needed some qualification to get into the USDA's portfolio to qualify some of our constituents. So the MOU was introduced again, and now we have the MOU between USDA, Guam Housing, and CHamoru Land Trust. So we're here today, and we're still stuck because we were trying to be creative to create some cash flow, and somehow we were at that point where the municipal golf course was at the verge of not having any customers from the tourism or from the local. So this was one of the creative ideas that came in, and my question with the GICC is that we were projecting to have an advance payment of 26,000 per month. That was the current rate. But then if the proposal was that we need 17 more years, are we going to stay at the current rate, or I think that we should reappraise the value of the property and go at that current fair market value versus the current value today?
Commissioner, I think you're right. So when we first ran the numbers, originally, all we did was project it out based on the current, right? So our proposal is, one of the improvements that I think we should do is to treat that extra 17 years independently of the current ground lease and have that appraised so that you get a more accurate reflection of you know, and you guys, you know, we want the commissioners, want the Chamorro Land Trust to pick its own appraiser, so that it's completely independent, for those 17 years.
So we're here today again, and we know that 38 is in now. How would, you know, what's the condition of the 38 with this?
I think what's that, Senator Sallerstein feels very confident, and then, in fact, what's that, we've always felt very confident, even with the previous legislature, what's that, but, you know, because of their internal rules, what's that, there's internal rules regarding how to get a bill out of committee, and then, you know, so really one person can hold it up, and then, what's that, but I don't think we're gonna have that problem, and then, what's that, actually, we had so much support that you could force it out of committee, but it just happened to be around Christmas, and a lot of people were off island, a lot of senators were off island, what's that, so, we weren't able to, you know, they weren't able to do that.
I also understand the environmental concern with the water, the PFAS, the endangered species, so, of course, you guys will have to go through the environmental requirement, and I don't think that the one EPA or the local EPA would give you guys you know, a break in case there's some federal requirements that needs to be met, so.
Yes, 100%. I think what's that, in addition to just the regular, the existing regulatory requirements and how to deal with development, but we could, you know, we put it in the bill, the safeguards, the original bill, the safeguards that the Land Trust Commissioners had requested, and we could, again, improve upon that. If there's any specific things, right, that you want to add into that bill, right, to make sure there are those additional safeguards, once that, we're fully, you know, as an advocate of you know, solar farm, I'm a true believer of protecting the environment. Once that, and so whatever ways we could improve that by legislation, we're all for it.
So, that's it, Madam Chair.
Madam Chair, may I?
Sure.
Thank you, Jerry, Carlos, for your time. Couple clarifications here, if I may. You mentioned something about receiving a letter back in 2019. You provided to us as a copy that part of the thing was that they provided the lease for the rent reduction, and then you were commenced on January 2023. You mentioned that the Commission agreed or granted a 3 months clause that you're performing within 3 months. You mentioned that?
Oh, that was I think Commissioner Guido wanted to make sure that we're on a tight leash and make sure that we're making payments, and we're to, if I remember correctly, it was to come back in 3 months to make sure that there was payments being made.
Okay, so if we take that and look at exactly where you're in compliance based on this April 19, 2022. I'm looking at a statement here that basically says that you weren't in compliance, you failed to meet the 3 months plus additional, so January 23, February, March, April, there was no payment made. And then if we discuss the fact that the payments must be made monthly, and you want to make it every month, if I look at the history from acting director on the plan, we see that your payments are not coming as consistent as it says. So to clarify that you're making payment on time is not according to what's saying here.
Yes, if I may.
And I'm sorry, go ahead.
I'm sorry, Commissioner, I have a response when you're finished.
And that's basically what it is that you must make payment
Okay.
consistently every month, and
Yes.
your payments are, again, I'm gonna go with
Right.
April 19, 2022, and the letter basically says that you're deferring only up to December 2022, with payments commencing January,
Yes.
and payments will include the normal monthly lease payment, plus additional payments that will apply to the rears.
Yes.
Again, that was not fulfilled, even to this date, when you look at back in September and October,
Right.
your payments were coming in on every month.
Commissioner, what's that, sorry to interrupt you, but what's that, I think it's important, the reason why I'm interested is because what's that, there is, there is during that time when the payment plan started, what's that, there's correspondences, I think Mr. Cruz can show that because of that letter that I presented with the former director, what's that, it says, okay, you just gotta pay all the arrears by October 2026, but there was no indication of what was the amount per month. So around that time when the payment was going to start, we tried every attempt to contact Director Cruz to say, hey, what is that amount going to be? And there's this documented correspondence about that. And then what's that, when we couldn't get a response, right? We tried to make some type of payment, it was rejected. It was rejected, and we didn't know what to do. And what's that, so we did the best that we can, and then what's that, and then that's when we have these series of meetings with the CHamoru Land Trust Commission and say, hey, you know what? What's that, Attorney Miller, I'm not sure if that was you at that time. What's that, it was that, hey, you know what? The previous AG's office was going to come up with a documented payment plan. They're going to prepare a payment plan on ink and paper, right? And it was never done.
So I understand that, but if you follow the lease agreement, when you take a look at your lease agreement, you do have what you think the payment plan basically. If you're commencing every month, February 2019 to 5 years, you have what your monthly payment will look like every month. So the onus is really on you as an individual. If you're making the monthly payments on time, you should be able to determine exactly what your payments are going to be.
We tried to get an understanding of what that was, and then what's that, so, right, and we never had that, and then, and we never got that payment plan prepared by the AG's office.
Right, but still, you got a monthly payment to
Right,
fulfill,
so-
and every month, it tells you on your lease agreement what your payments are. Whether you're delinquent or not, it tells you you must fulfill that obligation on a monthly basis. So when you look at that escalation clause every 5 years, you already know what your payments are gonna be. You know already that you are in default, in arrears of X amount, but your payment still needs to be made no matter how. When you look at the April 19, it tells you you make payment plus whatever arrears. So you pay in excess, it'll go to your arrears.
Yes,
So we understand that.
that's right.
But what I'm bringing up is the fact that your payments are not being made timely per your lease agreement. And your lease agreement basically states that it must be made monthly. We're not seeing the monthly payment being made consistently. And that's why I bring it up, because I need to point of clarification that you're not paying every month as agreed.
What's that, we just got this statement today, so I have to review it, right, and I will respond. What's that, I have to review it with Yohei, right, and then we'll see which particular months and,
So, understood. So have you ever been delinquent and not making payment consistently every month? Has payment been coming to CLPC every single month?
No, I mean, sometimes we miss payment, yeah.
I understand that, that's part of your lease agreement, says every month.
Yeah,
So-
I mean, we have been talking about this kind of matters with commissioners before, and that's why we are here. Our business is bad, and then that's why we came here for the solution, and then we are doing our best to make payments. And then, as you can see, you're right, Commissioner, we have not paid fully on time, but we have made payments. What this describes here as a balance of 414 is when we promised to start payment, when we had that letter from former director, he doesn't say, as Jerry said, he doesn't say how much we have to pay as arrear. He doesn't say. So what we did is we divided the remaining October 2026, that's what it says in the letter. So we divided remaining month, and then that we came up with around $17,000. If we pay every month $17,000, we will catch up by that. That's our goal. So sometimes we couldn't make a payment.
Understood. So what the CLPC did was gave you the leeway to make payments on your own for the arrears. So that was a courtesy to you, not saying, hey, make this payment, and then you're committed to the payment. They gave basically a courtesy, said, what's your arrears? You decide, you tell us, and you pay it, based upon the way I'm reading this. Now, that's one thing. You brought up another point, Jerry, that in terms of government officials and not being notified when Department of Agriculture came out.
I'm sorry? Yes.
You were saying that,
Right.
you talked about Mr. Young here,
Right.
who's basically acting as the director of the Department of Agriculture, and you know, so part of your lease agreement states that you must allow internal agents. If COPC came in and says, hey, you got so-and-so. But when you provided a supporting document,
Right.
I'm looking at September, on June 15, it says that Mr. Megan goes stop. And then, again, we're just following through to make sure that we're following the process itself, because your lease agreement says that if in the event that you're notified of a government vehicle, you must allow them to come in, not deny them. So we went through the whole process of not allowing them. That's a violation again of the agreement itself.
No, I think what's that, it has to be an official act of the government. And what we were concerned was that this was not an official act because why would the Department of Agriculture, right, contact Mr. Young to set an appointment to do inspection of GICC, but Mr. Young is not an employee, not a representative, has zero relations to GICC. So we were concerned that there was some type of miscommunication, and we simply asked, please have Department of Agriculture contact us directly. But that's it.
But it would be through COPC, through the property owner site, so I guess that,
If I may, so Ms. Megan did reach out to CLPC. That's why the initial letter, or the initial site inspection was arranged. And then we did issue a letter to Mr. Yohei informing him of this potential lease violation of not allowing us to.
Again,
Right, so I
to
think, I think once it became an official request from Tribal Interest, we did, CLTC did accompany Mr. Yohei to do inspection.
I think there was.
You did allow CLTC, correct?
Right.
But you didn't allow Department of Ag. You requested that the director provide a written request
Right.
as to the reason and
Right.
things of that nature.
So I bring that up because it is a violation of your lease agreement. You basically, CLTC is the owner of the property, and we are working in conjunction with other agents going in Guam. So they are part of it, so by denying one agent, you basically violated that lease agreement. Again, I'll bring,
Right.
it's in the section of usage comply with all above existing laws enforced or to be enforced. Okay, so that's one. Another part of the lease agreement, and I need to get clarification now that you guys are here, is first to get clarification on the lease itself, is that part of the lease, I understand, I have some time, this is very critical. We must discuss this, so I'm sorry, Mr. Burrito, but we gotta respect the fact that they're here so we can get some clarification into why these lease agreements that we provided are in violation. In the lease agreement, it says that, this is dated back in 2014, so I think you're pretty familiarized, Mr. Yohei, on the terms and conditions of this lease. Can you clarify whether there are 3 monitoring wells within, that has been installed? Are there any wells?
Yes,
Has there been any quality certification to determine whether the water lands,
absolutely, yes.
were, Commissioner, Acting Director, have we received any copies of these, what do you call it, reports?
Recently, no.
When was the last report that we got from GICC regarding because according to the lease, it says that the water wells is to be analyzed at least once every calendar quarter to determine if the water lands is being contaminated, and if contaminants are found to immediately stop using chemicals caused by such contaminants. So when was the last time that the wells were analyzed?
I would need to go back to the file. I don't remember that offhand.
Okay, so currently, we don't have anything currently, and it says quarterly, so we are already in, if I looked at September, October, November, did we, or October, November, December, have we received anything?
In December, no,
Nothing. What about the year before, or the quarter before?
I know.
So I bring this up because the lease agreement again, specifically states terms and condition must be met. We violated that terms and condition, unless we have the current quarterly.
Right.
I can't answer that, only you guys can answer that,
Yeah.
but according to Acting Director
I
Cruz, we have not received anything.
I think it's important to definitely, provide those to the commission. So really, whether it was done and whether the copy of the reports were provided are a few different things. So really, if they're done, right, you have to make sure that you provide those reports.
I will do it.
Now, we talked about the solar farm. We talked about the thing. One of the questions that is, I need, basically can try and get a clear understanding is to put GICC, CHamoru Land Trust property onto a request for bid from out of CCU. What process does that take place? There was a section in there that back in March, there was a, CCU had the Consolidated Commission on Utilities Resolution 2429 indicated that GICC put CLTC property up. So was this before that we decided to do a solar farm, or was this something that you consulted with CLTC that, hey, we're gonna do this, just let you know that we're gonna put CLTC property up and go through the bidding process for the solar farm?
I'm not familiar with that, I wouldn't be able to answer that.
So, therefore, there are two companies that are working closely with GICC.
Uh-huh.
You're familiar with the two companies that you're working with for solar farm?
No. I mean,
If you're not familiar, then how?
I'm not sure what you're referring to, Commissioner. The first thing that you're saying was, even the very first part.
Okay, so in October, fiscal year 2024-29 is the resolution on the CCU that shows that GIC, which is CLTC's property, was put up on a bid. So the property basically,
2024?
yes,
The property was put up to a bid?
meaning they're gonna use, there's two solar farm companies that's gonna put solar farm
Oh,
on
you mean
CLTC.
for, what's that, the GPA bid?
Right, CCU,
Right,
basically, that's what the
okay,
CCU,
okay,
right?
okay.
So, you're familiar with, so you've been working with these two companies?
What two companies are you referring to?
According to this, so, well, you talk about solar farms, so in
Right,
order to
right.
understand the solar farm, I need to understand, here it shows that you're working with two companies, you're saying you don't understand or you're not familiar with the two companies. What I'm trying to gather is, how can we then go and talk about a solar farm and not knowing who you're working with, but yet we do? So I'm just trying to get a clear picture, understand, so I can really answer.
Right.
If it's okay with you, Commissioner Bettis, if I can sort of reframe your questions a little bit. Does GICC, does the lessee intend to develop the solar farm itself, or do you envision that you'll have a partner for the development? And if you envision having a partner, is there, do you have a deal in place with a partner, or is that to be determined?
I think what's that, I have to answer that properly, what's that, because, within the, our responsibilities, like, for example, right, what's that, I'm not the developer, I'm not the solar expert, what's that, so I have to defer that to get someone to answer that, but now I understand your specific questions, and we could respond to that in writing.
And then I think the follow-up question would be, does GICC and/or its partner, assuming there's a partner, do you have a official or tentative deal in place with GPA that, you know, you will supply power to, this much power to GPA, and GPA will pay you this much money
Right.
for that supply power?
There's no, I don't think there's a power purchase agreement in place.
Well, it may not be a power purchase agreement, it could be a contract agreement between the two parties that says, hey, I wanna work with you to do this, let's go together, and then you guys do whatever you guys want to do. So right now, it seems like you're not too sure about who you're working with, what the companies are.
Right, because
But yet,
that's not my jurisdiction, so but
But
I
this
wanna
is-
make sure that,
but we're talking about GICC, so.
yes, but I'm
Mr.
not responsible for everything at GCC.
So, Mr. Yoni, are you familiar with what's going on with the property itself?
Well, I am the general manager of GICC as a golf course, and I do not aware of the two companies you mentioned.
Yeah, I'm not really sure which
So,
document you're
okay.
referencing.
Then how can we put a solar farm and say we want to put a solar farm onto
Mhm.
CHamoru Land Trust property?
Right.
If you're not familiar with what's going on, but yet we're holding back with all the bills and not cleaning up, not doing
Mhm.
maintenance within the municipality based on your agreement with CHamoru Land Trust. So if you're not familiar with all that, then who is actually giving or advising or providing the authority to use
Mhm.
GIC property,
Right.
so that we are clear amongst our commissioners, the public, our attorney Miller, acting director Cruz, so we understand what's going on, because I, honestly, I have not, you're not familiarized, you don't know who's doing it,
Right.
but,
So
yeah.
I wanna give the commissioner and the Tribal Natural very accurate information, so I will respond to that.
Commissioner
Right.
Ibanez, I think Mr. Camacho can answer your question, because he's the one that's, has the idea of.
Okay,
True,
sorry,
but I guess the managing director is Mr. Yohe,
Yes,
but
but
he's not familiarized with what's going on, so I understand, Mr.
Mr.
Camacho.
Camacho can
You can provide
explain
that.
to
and
you.
let me explain, if you guys are familiar, US Congress in 2023 passed the renewable energy tax credit. Just like all the tax credit projects I've done in Guam and housing, we have to sell the project to the investors to generate the cash flow. So what they did for Guam and the United States and the territories of the United States, Congress passed, and that was in our original presentation, that there's a tax credit with investor institution, companies in the United States will buy these credits and energy so they can get a tax offset and they get the depreciation schedule. So we don't know who the investors are at that point, because we don't know yet if they got the bid. Again, the bid, we all know that GPA put out an RFP, you're correct, Commissioner Banis, an RFP. And that was based on the public law that was passed by the last 36th legislature, so that Guam can get into the renewable energy. Now, we didn't get no project. Well, what we did was we did the preliminary. You can submit any project, get it if you're gonna meet the conditions and terms. That's it. You don't get awarded until you get either the law change or the rules change for your property. If we don't get the rules changed by zoning it correctly, then we don't get awarded. So we were never been awarded. We always do, as an advisor, I do the preliminary work on getting the economic opportunity, and I'm the one that provides the tax credit investors that Congress passed in 2023. And on our original presentation, when we did this to more land trust, prior to your term, Mr. Danis, it was there showing the federal statute on the tax credit. Again, as I described, the tax credit, we don't know who the institutional investors are yet. If we do get a project, We take the project and we put it out like I do my low-income housing tax credit projects, I do it, and then we get our investors. Then the investors has to become a partner of our solar farm in order to earn the tax advantages based on Congress. I mean, that's a different animal in itself. All we're doing now is trying to get the property rights and the property changed to a solar farm
So,
in this case.
thank you, Mr. Camacho. Now, the question then basis is, we understand that's the whole process itself, but how did CLTC land become part of the notion of, let's use the land for the solar farm without getting permission from CHamoru Land Trust? How did that?
Well, don't forget, we got a resolution from the previous board to do a solar farm supporting 179.
No, but,
We got a resolution from the deputy mayor. We had a pre-concept before that, just like any development we do. We do a master plan and we check, do we meet? Are we gonna do single-family housing, multi-family housing, or a solar farm?
so,
If the solar farm's infrastructure is far away, like the other two projects, it may not be cost effective. But in this particular case, it was, the GPA substation was right parallel to CHamoru Land Trust, JCC property. This is what we did. We want to make sure we met. In order for us to get a copy of the RFP, you gotta submit. You can't just get it, you gotta submit so your name, you can review it and get it. We never submitted a bid. We were getting the parameters and the guidelines on what they're looking for. There's no public work interest in this government, what they're willing to pay for, what price they're looking for, and based on that statute, they needed to get 50% of their energy needs by renewable. So we saw all those check marks, and we were just doing our due diligence. If we did our due diligence, me as an advisor on my side, saying it doesn't make financial sense to do it. For example, let's say like Marble property, the infrastructure was miles and miles away to connect to the substation. The Interrahman property, miles and miles away. If it did not make sense, then there's no use to us doing a solar farm. So we need to see what was put out of the RFP. But that doesn't mean we were granted a bid. We could not bid because we did not have site control and the rights. We got the site control, but we didn't have the rights to use it as a solar farm in any deal.
understood, thank you. So, the question then becomes, if it was your resolution, I'm looking at a resolution on CCU, FY 2024-29, that's way before the resolution from CLTC. So the reason why I bring up is to understand how the GICC, CHamoru Land Trust property, was put into this bidding.
Okay, that's a good point. You brought up a good point.
I know.
Again, I want to make it clear, it's not a bid. We were just doing a due diligence to make sure we meet the underwriting criteria and their proposal.
True,
If
but-
we don't meet it, we won't take the next step.
True,
We
but
won't work hard and push you forward.
when you put CHamoru Land Trust property on a bid,
No, not a bid, not a bid. We
Well-
did the due diligence and submitting, hold on, my battery's gonna die.
Got it.
Change, one second.
well, it's a potential bid, because if you win in the bid, then you become then you start producing and starting the next process into the solar farm. But that's the question, is how did CLTC's property become part of the thing without getting permission? And part of the lease agreement is that you must get permission from 3 individuals before you proceed forward in doing anything.
You're correct about that. That's the reason we went through the legislative process.
But you
Because
must-
we did not have the zoning rights to do it.
Yeah.
But we're doing our due diligence, so.
Right, but you must get,
That's the reason we're going to the legislature under 179, so we can get that approval to change the municipal lease approach that was approved by the legislature to a solar farm. If that was never, let's say, for example, you got voted down, then this issue is moot. We would not move forward. We would either move forward as a golf course and try to figure out how we're gonna survive in this, seesaw economy, or when we have the opportunity to look for a diverse economic opportunity based on the public law they passed on the solar farm and based on the infrastructure that's close by. That's the reason we did the due diligence in putting this together.
Understood, but,
Again, it's only due diligence, sir, Mr. Vanis. We didn't
understood,
sign no contract was awarded.
no,
It's just like doing a preliminary example and doing I take a road land, it's agriculture. You got sewer next to it, and you said, Carlos, what's the highest and best use? Well, either it's commercial use, or either it's R1 or R2. Then I do a master plan. And yes, I gotta go through the process, to the agency review committee, the land use commission, because they can always say no. They can say, no, your infrastructure will not fit, because the water and sewer capacity is already outdated. There's no way you can do it. We still gotta do all our due diligence. We can't just go blind into the project by spending hundreds of millions of dollars and convincing our partners, our tax credit investors, to put up this money. So, like I always do in all my projects, we do all the sub diligence at our expense. There's no expense at the CHamoru Land Trust. We do that at our expense and make sure it's diversified and our economic base is sustainable. That's what we're doing. Subject to the legislative approval. Again, as I stated in many meetings, if we don't get the approval, then we don't get it. It's either voted up or voted down. We just need the democratic process. But it's the legislative body who originally changed that land to a municipal golf course, and it's gonna be the legislative body that can change that to a solar farm for economic stability, for the benefit as Jerry described, for the CHamoru Land Trust Infrastructure Fund, and meeting the statute of reducing the energy expense to the community as a whole. So it's a two-way win, and that's how we saw it. And
understood.
again, we're not buying the property and taking it away from you guys. It's just an extended lease for 17 more years. If we lose the bid, because again, if you look at the proposed legislation, it's subject to us winning the bid. We don't know if we're gonna win the bid or not,
So,
but we still gotta do our due diligence.
true, I
And if
understand.
we prematurely did it, as you stated, we apologize for that, but there's no intention for us to sign a bid without COTC's approval. That's the reason we went through the whole process and got you guys approved through a resolution. And we got the resolution vetted, and we were still waiting for the legislative approval, either up or down on the 37th. That's where we're at today. And most importantly, you're right on our payment. Other than the 2 or 3 months hiccup that you saw there that we'll verify, we've been making payment as committed up to 2026 on the existing lease and the arrears. So, hopefully that can show our good standings. I mean, I've seen a lot, again, I'm not gonna point fingers, as I've been there for 2 years and many years watching. I've seen a lot of the commercial properties, not mentioned, same in my geographical area in Delano, that hasn't paid any lease for 20 years. So I just don't understand what's the reason, and which is okay, it's good to have this debate before we can figure out a win-win situation, but in other leases that hasn't paid lease for 20 years.
I know, that's beyond the point. We're not really focused on what we have in front of us.
With you and them now, they can change that approach. But I hope you can give us the opportunity. We've been up and up. We've always been in every of your meetings. And whatever we do through public hearing. And we've got to go through the legislative process, either voted up or voted down. That's all I can say.
Thank you for acknowledging that you went ahead with putting COTC property without getting proper approval. Now, part of the lease agreement basically says you must, before you do anything, you must get 3 approvals. COTC is one of them, the governor is one of them. The legislature is another approval, but you must have 3 before you decide to move forward into any type of formatting of your lease agreement.
Commissioner Banish, you're correct. I'm glad you mentioned the governor, but that's what we thought. if a bill was passed at the legislature, for example, the governor has the opportunity to veto the bill or approve the bill. If she approves the bill, then yes, you're right. She will accept the conversion to be a solar farm. If she vetoes the bill, then we're back to zero. We're back to the original intent of the golf course, was GICC. So you're right, the governor plays a role after the legislative process. And if we jumped the gun too quick, before we got the resolution, our intent was, since we started that 2 years before we got the resolution, when they asked for economic diversification, we were, again, doing our due diligence. And we apologize if we prematurely did our homework early, but that's the way I do my development and my advice when I advise my client. We do our pre-development so we know either it makes sense or doesn't make sense. If it doesn't make sense, we won't even be here 2 years later. We will just end it and stop and just keep it as a golf course and I'll move forward. My expertise is only the tax credit part on providing a investment vehicle that was passed by Congress, like my examples I did with the low-income housing tax credits in Guam. That's the only reason I got involved.
Thank you. You know, and it brings up another point, knowing that nobody's familiar with how CLTC property came in and how and who the power solutions are. It just further brings up red flags because if you're putting a property that belongs to CLTC, they must be well aware of that they're using their property itself, so you can't encumber it without getting first permission. And what we're seeing here is that we're trying to encumber it, putting up, provided that we win the bid, and if we win the bid, then it becomes a slap in the hand, says, I'm sorry, I won't do this again, but I did it, and now we have to abide by the following. What I'm actually recommending is that we follow the rule, follow the lease agreement, so that we ensure that proper compliance is in order. When you say the legislature and the governor and the legislature and CLTC comes first. They must come in with approval, say, yeah, and then we can proceed in saying, let's go to the legislature to put up the bill in itself. Because the lease agreement is straightforward. I'm following what the lease agreement, what was signed. So what I do see is that there are a lot of violations in this lease agreement in terms of what I brought up, that we really need to ensure that we're following these lease agreements, especially in the terms of the payment plan, the monitoring wells, that's critical. If we're not seeing the reports on these environmental analysis, we won't know. And if that's a failure, then we need to ensure that we get in compliance with that. The other thing, you know, we noticed that the property, again, you talked about it, but it's not, we're seeing that, you know, the upkeep of the property is not being kept. There is, I think we did a last inspection out there, and there is individuals staying there. Acting Director Cruz,
I don't
you have a
have,
picture of
I
that?
don't, let me ask to put in a picture. So, as we mentioned earlier, the last site inspection we did when Ms. Connie was the GICC employee who was there, we did take some pictures, and there are some concerns. Dexter, can you send your pictures for the hanging of the clothes? Can you go down more? Go up. The first picture. So this picture here, the first picture on the second floor, there was clove lines on the second floor with clothes hanging, I guess, to dry.
Yeah, nets.
So that's one of the, we don't know because we didn't go in there to find out, but that's part of the pictures that were taken. And then there's other pictures.
What is wrong with the drying clothes side?
No, what it looks like, based on also when we went out, was it looked like there is using as a, somebody staying there, in a sense. So you have the net, fishing net there, clothes hanging out there, the goats are running around, so it seems like it's not maintained as a golf course, it's maintained as a farming or residential unit, based on, and that's, yeah. I mean, that's basically what we saw when we went out.
So there's other pictures that we took. So that's all the pictures that are on this report.
Okay, that's the one.
That's the board.
That's the more,
Yes, the more.
we have like, 3 we saw that day?
3 or 4.
4 that day?
Just in that lake, there's more.
No, there, we went to,
Oh, yeah.
we went to all the lakes.
Oh.
When we went out, we saw it. So, but Carlos, I do thank you for explaining your, and clarifying some of the questions I have.
If I could add one more thing, Commissioner Banas, those are good points you brought up, the statute, and I wanna, wait, I'm sorry, I want to, maybe CHamoru has cited us in that in the last 8, 10, 12 years, that I don't know, but, I think, like you said, as you identify those, we want to assure, like for the water wells, if there is any inspection we have to do. I know that GWA and EPA, and I can probably get a copy of that, because other projects that have water wells, they maintain the water wells and they monitor that, but that's a good, that penetrates from the drinking water from Guam. So we can probably get records from them if there's any contamination or not, but if there was, they would have closed it and make an announcement, but we haven't seen that, but we can get a copy of those inspections from EPA and GWA.
Yeah.
EOA doesn't have that, I can probably get that.
No, we-
If I'm not mistaken, I can't speak for EOA, but, EOA, maybe you can confirm if there was someone staying there or not, because of vandalism and theft to the area.
Exactly, yes, yeah, exactly what you said, yes, we have a lot of thieves and then robbery. About 2 months ago, we have someone, broke into our clubhouse. We called the police came right away and then they arrested him. But that's why we have someone, stationed there all the time to watch, our location, yes.
But
Yeah, so,
it appears it's more like a farming home, because you got goats running all around.
There's only one goat there. I originally goat there. Originally had goat as a tourist. There's only one right now, sir.
One, right.
Yes. And we had that goat before because it was we thought it was a good tourist attraction. For the gophers and then to enjoy, and we have a lot of wild chickens, and then a lot of visitors liked the wildness, and then they most of them enjoyed having a goat on the golf course, and they take pictures together with goat, and that's the original reason. I mean, we were of course not there to farm or to to raise goats. Right now, we only have one goat. Yeah.
Carlos, if I may, during that time of our visit, just to make it known, Acting Director Joey, the individual that showed us around that day, what was her name?
Miss Connie.
Miss Connie basically was afraid of that goat. She made it very clear to us. That goat has horns, and I believe we saw 3 that day. All fenced off, there's one that's roaming around, there's one in the bottom fenced off, so it looks like it's a farming site. My concern, the reason why I bring it up, because acting Joey Cruz basically made it known, I believe through a letter or what, that they're supposed to mow the land at a certain period of time, and that you mentioned something to that effect, that.
Can we
I'm not.
stop now and let's get to the other things in the agenda?
Yeah. So
Stated your point.
yes, so
So,
I do thank each one of you, Jerry, Yui, Carlos, for meeting with the commissioners today to further clarify the intent and to bring up our findings and the violations, which you have the financial, the environmental, the land use violations. In addition to all the others that we discussed, I hope we can, as a board, as commissioners, take a look at this closely before a decision is given made.
Okay, Commissioner Banis, thank you for the opportunity. And again, we apologize that, I apologize personally as one of the advisor, that if we jumped the gun too early, subject to the governor's approval or the legislative approval. But our intent is a good intent to help fulfill your mission and goal. If we did violate 2 or 3, I'm glad you mentioned that, so we will make sure, as we did during this public hearing process, putting more teeth into the bill to put what you guys want and needs. So if it's regarding the protection of the moorhen birds, if it's regard to the endangered trees and stuff, we'll make sure if such bill gets introduced again on the 38th, that these language are more clearly defined and clearly stated.
Yes.
And all that. So we're not here to fully violate and close our eyes. We want to be great partners as we've been. I'm rooting here in Guam in a while, so when I took this opportunity to advise them, I wanted to make sure, that's why we agreed on regulatory process, but all these other issues you brought up, I'm noting that down so that if we can put more teeth into the potential, if it happens, that should be that a operating agreement or standard operating procedure is followed to the T. So I thank you for dissecting the policy and informing us, but it's well noted, and but again, no intention is here to harm. Our goal is to try to economically sustain this operation. That's what we're doing.
Thank you, Carlos. Just for history purpose, GICC has been delinquent for numerous years prior to this, from me coming in. So just so you're aware of this, so you understand that there's more to this than just what we're seeing right now. The history of delinquency has been in the past.
It's a good point. That's a good point. If we're not able to get the financing to cover these arrears, try to make it prepay this net present value, then you're right. If you had a history with a CSR economic payment back and forth, because of economic reasons, SARS or COVID or whatever, then you're right. We had a seesaw event for many, many, many years in the past, and I wasn't there. But what we're presenting in this legislation before, and I don't know if they're going to do one now again, it all depends if it's going to be introduced, is the net present value prepaid. If it's not prepaid, right, then you're back to your month to month, and is economy good, economy no good? We're proposing a prepayment and how we're doing that. And that was a question that was brought up by the previous director, Birch. Well, how are you going to prepay that? Couldn't pay the arrears. One, that's my part is the tax credit investors coming in based on the federal statute that will, and the Guam policies that will make the renewable energy a very effective economic investment. And if it doesn't happen, it doesn't happen. But if it happens, then you guys don't have to worry about an annual payment because it's all prepaid in advance, if it happens. But that's the stability that I'm putting my neck out, and my name out in this project. point of the agenda. Thank you again for the opportunity and the back and forth debate here. Thank you very much.
Madam Chair.
Yes.
Mr. Tan, are you familiar with the term quiet enjoyment?
Yes, under the lease agreements,
Can you explain what that means, please?
for tenants, what's that, it's usually, Attorney Miller, if you could correct me if I'm wrong, it's a protection for tenants to, that landlords would give them a quiet enjoyment of the property. Basically, a quiet enjoyment is something that landlords give to tenants.
And that would be, how would it apply?
To you.
Oh, okay, so what's that, over here, what's that, landlords would, under a lease agreement, the landlords would not interfere with a tenant's right to use the premises, in accordance with this lease agreement.
Were you given proper notice for Department of Agriculture to do a site inspection?
We didn't feel that, we received any notice from Department of Agriculture, what's that, and when we did that, if we put this in context of what's going on at that time period, what's that, there was a lot of, you know, the opponents to this bill, some of them are here, what's that, they're very powerful, very well connected, and what's that, there were things that were, you know, done by other agencies against the Open Government Act that we also mentioned in the June letter. And so, yeah, maybe there was a little bit of paranoia on our part, what's that, but I think it was justified given the extent of the opponents and manipulating media, manipulating government agencies, what's that, so, yeah, we were very concerned, and that's why we invited Director Munoz from the Department of Agriculture to just confirm that this is an official act of the agency. You know, it's been a long journey, and I just like to, I know we spent a lot of time on this, and at the end of the day, I'm just gonna go back to speaking from my heart, because what we're here today is because we're trying to do something for the beneficiaries of Chamorro Land Trust, and my position has always been the same, that, you know, sometimes I've been experienced, and originally I came up with this idea, it's a fantastic idea, do some type of endowment fund, right? Because I felt like that's a third revenue stream, and then I think the commissioners very wisely pointed out that you can't really just lock up money and then trying hands, so we abandoned that idea, just, revise the bill to allow the commissioners to best use the funds as it sees fit. And then, and my feeling is that the opponents of this bill, for some reason, they feel okay to come to this office and prioritize golf over the housing needs of the beneficiaries of Chamorro Land Trust. And they're sitting right here behind me. I just don't get it. I don't get it. This is Chamorro Land Trust property. Chamorro Land Trust mission is not to operate a golf course. It's to provide housing for the beneficiaries. Let's say we have to use those terms very carefully because of the U.S. Constitution, how we define the beneficiaries. But I think, we're all talking about the same thing. What's that? And I encourage the commissioners to focus on the big picture, and also what's that mission of the Land Trust, and what's that, and the reality is that private golf courses are not surviving on this island. The reality is that if you take a look at the GDP reports, what's that, the Guam visitor arrivals is still less than 50% of pre-COVID numbers. The reality is the golf courses on Guam, the private golf courses, for-profit courses, are losing $500,000 to $1 million a year. It's not sustainable. The reality is, El Popo Golf Course, Onward, Manila Golf Course, they're still pending at discount rates. The reality is, Starts Golf Course sold last year, discount rates. I just don't think that a municipal golf course with subsidized rates is sustainable. And I don't think that the people who think that they're gonna, who's made a concerted effort with other business people to take over this course really realize what they're getting into. And I don't think they're gonna put $9 million towards the land trust to fund its mission. Anyway, so, thank you, commissioners, for the time for the opportunity to appear. What's that, I will, I think moving forward, I really like to be able to stay in closer contact. I think that, I think where we probably, can do a better job, 100%, is meet more consistently. I think there was long periods of time, right, that we didn't meet up, and I think that type of, absence of communication is actually, not good. So I do appreciate the opportunity. I know there's other matters. I've attended a lot of these meetings, and I don't want to take any more time because the constituents are actually the most important. What's that? So I'd like to, but if the commissioners think that it's productive too, right? We'd like to appear every month just to keep everybody up to date twice a month. Right?
I've got a few more questions for you. The next question is, on the island of Guam, what is your estimate of the total number of golfers?
Okay, I think I have to defer to Yohei on that. What would be your estimate?
Locally, or the?
Locally.
I cannot say, I mean, it's just coming up from, it's not accurate.
Well, estimate.
How many golfers? It's not,
1,000,
I have how many?
2,000, 3,000 golfers?
Maybe, Russell can answer.
Probably closer to 8,000 to 10,000 golfers.
8,000 to 10,000 golfers?
That's a lot.
That's a lot.
Well,
Yeah.
yes,
Yeah,
I guess the concern there is,
So,
I'm not talking about avid golf,
Yes,
I'm talking
yes,
about
the
people who
constituents.
play golf, people who
No,
go to
I'm-
the driving range,
I don't believe that.
Jerry, my question connected to that now is, are you aware of how many power ratepayers there are in Guam?
Yes, there's over 30,000 ratepayers. And what's that? And I think the reason why we can't really answer that question, how many golfers, is because I'm part of a golf club, and I golf maybe once, twice a year. I don't really consider myself a golfer. I'm an alcoholic, but yeah. So it's really how you define a golfer.
That's all for now.
Thank you, Commissioner.
so you do understand that the lease agreement to enter was a commercial lease agreement, and that was the whole point of entering commercial. You brought up our mandate, which is the residential portion of it. The commercial came in at a point in time to provide infrastructure to the rental payments for these beneficiaries. Therefore, through that, we'll be able to fulfill the mandate of ensuring that they have the infrastructure. But at the same time, when you enter into the agreement, you fulfill that obligation to make your monthly payments on time, to follow the lease agreement to the terms and conditions itself. Knowing that these are all there, there's, this has been happening for quite a while. Just so that we are aware of that thing. But I do want to bring that up. Thank you.
Yeah, thank you very much, Mr. Banis, but we have to continue.
Thank you. Thank you. Thank you, Director. Thank you, Chairman Miller.
Madam Chair, if I may, since we're still the topic of Guam International Country Club,
Only
I
a
want to make a
couple of
motion.
minutes.
The motion basically being that knowing that they admitted, knowing that through the media site, through them opening up, that they're not aware of any of these things, we asked specific questions that they aren't even able to address. Based on that, the fiduciary of our, as a board, we need to make sure that they understand how the legality format of this is very important. Madam Chair, my motion basically would be to ensure that one, have Attorney Miller prepare a notice to OA, understanding that what we just went through in terms of the violations, so they are put on record and documented properly. If in the event that we do decide to terminate their lease, we have supporting documents to bring them up to par. I know we brought that up to ensure that they are in compliance with the lease agreement. Mr. Hoyer also brought up that he wasn't aware that there's supposed to be water, he was not aware that he's supposed to submit these water reports over to us. He's not aware why GICC property was being used, who the companies are. So it just brings a lot of red flags to us as a commissioner in terms of their obligation to fulfill to us. And in order to do this properly, Madam Chair, before we even decide to terminate, we must provide notifications so they're aware and give them the proper ways to cure it.
Well noted, but I would like to ask also our administrator, those things that Mr. Ibanez has said.
We'll work with the treasurer to drop the letter or the notice.
Yes, but those things that they did not, like agriculture and all that they are not aware of.
So,
How often do these things happen? That is supposed to happen? Inspections?
the inspection?
Yeah.
So I'll give you a little history of how this all came about. Going back to them mentioning about the June 19 letter. So, yeah, and even prior to that, right? So prior to the extension in 2014, GICC was in arrears. Prior to the extension even coming up for discussion, then they got their account to current. I believe this is during former director Michael Bora's time. And then back and forth, like Mr. Camacho had mentioned, they pay, they don't pay, they don't pay. So I believe it was in right after the COVID, I believe in 2019, when the letter was issued, or prior to that, I believe it was you as a commissioner, Commissioner Herrera, and Chairman Regis at that time. We had presented 3 options to resolve the non-payment of GICC. At that time, the board had gave me the authorization to send what the board had agreed upon was option A, which was not to grant, because initially, Mr. Yohei had submitted a letter. He was requesting for rent deferment of 50%, I believe, for either a couple of years or something to that effect. But he will commence payment on November 2022. I think 2022? But because that didn't happen, we brought it to the board. But when, at the time when the board decided option A, and we did inform Mr. Yohei, we extended that and we emailed it, but Mr. Yohei didn't. Mr. Yohei responded, and since the board couldn't accept the 50% rent reduction, he'll try to comply with his own payment arrangement. And when that didn't happen, we brought it to the board in, I believe, 2023. And then it went on until April of 2023, when Director Alice Tyrone was here. And that's the time, I believe, when Commissioner Garrido had mentioned about a 3 or 6 month probationary period. And they allowed the payment plan, even though they didn't accept it. GICC, that was the concern. There was mention of, yes, our phone numbers did change. That's correct. But prior to that, there was email correspondences between myself, Yohei, Ms. Connie, and I believe Ms. G. So that wasn't, for us, when we presented that case, that wasn't a reason of not communicating. And yes, it's correct, we denied to accept his payment in January 2023 because he didn't comply with the payment arrangement. Yes, they did mail certified mail payment, but yes, we did return it back, which was served through process servers of CLTC, so that we don't artificially create an acceptance without the board's approval. So there was a whole issue with it. We were going back and forth about it. As far as properly notifying them, on June 2026, 2024, I sent an email to the draft letter to Attorney Miller for his review, informing GICC that CLTC with the attendance of Department of Agriculture will conduct a site inspection on June 28, 2024. So I don't know if 2 days is proper notice, but we do provide proper noticing. We do our very best to do that. In the event that somebody might not be there, we hope that somebody will be there. When we do get complaints, sometimes we become reactive and just go out and conduct the inspection. But we do our part to properly notify everybody about our site inspections. But as far as back as I can remember, going through the file, because when the whole GICC issue came up, we did a timeline that what we did for the Guam Racing Federation. We went through everything in file. I don't recall anything about the water testings that I've seen, and I can sit here and say for sure within the last 2 quarters, no, that we haven't received it. We have done site inspections with the employees here and with some of the board members. The state, we saw it 6 months ago, is the state it's still in today. So from the internal side of the CHamoru Land Trust, we do our best to properly notify, we do our best to ensure that compliance of lease agreements. Next month, since we're on the topic of commercial compliance, we're going to present quite a few who are not in compliance also, who owe maybe not the same amount of money as GICC, but date further back. But yes, we've done everything that we possibly could do to try to collect.
Madam Chair, if I may ask, Joey, a question. Based on what you just said and based on what's presented, is this, and again we could consult with our legal, a immediate termination for the lease agreement itself based on what you just brought up?
For that to Attorney Miller.
What does the lease agreement provide in the violation of, based upon what we just heard and testimony from the general manager, Jerry, what constitutes, Joey, acting director Joey, based on history, does this constitute a termination of GICC lease agreement with CLTC?
Well, certainly, the first thing a court is going to look at is, has your tenant paid as agreed? And in this case, it's my opinion that the court, a court, would take the view that GICC has more or less paid what they have supposed to have paid up till now. So it would, I think legally we have grounds to assert a payment default. It's a close question whether we would win on the question, have they paid as agreed? Now, the lease also says, we're leasing you this land to operate a golf course. And there is no doubt they are not operating a golf course. If it was your pleasure to assert that that was a material breach of the lease and you wanted to go to court as soon as possible and try and terminate the lease and take the land back simply on the claim, we gave you this land for a golf course, it's clearly not a golf course, if you're not gonna operate it as a golf course, then, go away. I think there would be legal grounds to take that, go down that road if that were your pleasure. Having said that, I think last year, the bill to change the use existed. We were all aware that, that there was the potential that the legislature might want to give the commission a different direction as to what to do with this particular property. And, I think a court would certainly look at whether or not, the fact that yesterday it wasn't a golf course, today it's not a golf course, tomorrow it's not a golf course, but really our boss, the legislature, is giving serious consideration to telling us, well, don't use it as a golf course anyway. That's certainly something to consider, whether the time is right to assert that it's golf course or nothing.
So knowing that they violated several of these, the wells not turning financial statements in per their agreement, the upkeep of the golf course to be a golf course, the monthly rental payments, not repurposed, asking for it to be repurposed without getting proper permission, putting GICC's, CLTC's property up for, and covering it without getting our knowledge, those can be used as determination itself.
Yes.
Okay.
Especially when a tenant is largely financially up to date. If you're nonetheless seeking to terminate a lease, what a court's going to focus on is what are called material breaches of the lease. And a court will distinguish between, for lack of a better term, technical breaches of the lease and significant breaches of the lease. In my opinion, the most material breach, the most significant breach is the lease says operate as a golf course, and they're clearly not operating it as a golf course. If it were the commission's position that, well, if we want it to be a golf course, we have an RFP ready to go to hire somebody else to operate it as a golf course, and we give these people one last shot to operate it as a golf course, and if they say golf's a loser, we don't want anything to do with golf, then I think we could easily terminate the lease. But it's on the facts as they exist today. Yeah, I certainly think we'd win, but they'd certainly give the judge something to think about.
With that said, do you recommend providing proper notification first before we decide to terminate, knowing that we have all that, or would you recommend that it is a termination clause to terminate? I mean, can we go under and say, okay, we're gonna terminate, and they'll come back, well, you didn't give me proper notification? Or is it part of the Guam Law that says you must give them notification before you proceed for termination? You're here.
My recommendation is, in the absence of anything at the legislature changing who's up, who has what obligations to who. If today, your preference would be to try and terminate this lease, my recommendation would be that we write them a letter that says, the lease says you're to operate this as a golf course, you're not operating it as a golf course. The lease gives you this many days to remedy the breach. We'll be back the day after the remedy period is up, and we look forward to seeing the golf course and see what happens.
So with that in mind, on December 17, 2024, a letter was addressed to Mr. Hoy. And that it does say that they violated certain terms on the form 17. Does this serve as a sufficient notice to terminate this lease agreement, knowing that it does say in there that conditions and these term violation of lease agreement, and the GIC can, and the GICC can be terminated due to non-compliance? Does this
Could be better.
could be better?
This could, if your preference were to be to direct us to terminate this lease at the first opportunity, again, my recommendation would be that the next thing we do is write them a letter that says, you're required to operate as a golf course, it's clearly not a golf course, and you've got this many days to operate as a golf course, and if not, and we will be there the day after. And if it's not a golf course, then the day after that, we're going to court and move to evict you.
Okay. So Madam Chair, with that being said, I make a motion that we terminate this lease, give them a letter to effectuate the crossing, to remedy and to fix the problems and become a golf course. Is there a time frame, 60, 90 days? What is?
I don't have the lease in front of me. There is in the lease, there's there's language which says if there's a default, we send you a notice and you have this many days to cure the default.
I'm not too sure, but Madam Chair, I make that motion to terminate this lease, put them on notice, that they don't cure the default of the lease agreement based on what we just discussed in terms of the violation of the wells, the financial statements, not operating as a golf course, and the curing is within a specific time frame. Actually, Cruz, can you assist in finding that term? That you must cure it? Oh, that's payment for lease agreement. Well, nonetheless, we can include that in there, but I make that motion, Madam Chair.
I rather that the lawyer does the letter first and state all the violations
We have a motion.
and bring it to the board for us to approve the letter.
I believe we have a motion on table to make a decision.
Anyone wants to second Mr. Ibanez's motion?
And the motion is to restate the motion again?
The motion is to terminate GICC's lease. Have Attorney Miller send out a letter to GICC General Manager to cure the default. It's not operating as a golf course, the maintenance is not being made, the violation of the wells, the financial statement is not being upkept, payment must be made on time in the delinquencies, and we give them a specific time frame to cure these defaults. We're getting the default. Once this is effectuated on that motion, Then it proceeds forward to ensuring that they comply as a golf course.
You know, Mr. Banis, they were right here.
Yes.
Why didn't you just bring
We
it
did.
up and tell?
We had
Tell
plenty,
them.
we had plenty meetings on this topic in the past. We brought it all out to the public's eyes. We had 3 or 4 meetings discussing GICC. Prior to me coming in, they had multiple meetings on this topic as well. We need to set the precedence in terms of our commercial leases, like I mentioned, and we have to continue to move forward in ensuring that our leases, as we made in the last meeting, that they will, Acting Director, Mr. Cruz, will provide a monthly log of all our commercial leases and determine where the violations is, are we following it, what the money payment is, all of this, and that's why we're here. I don't know if there is a term, but we should,
There's a motion from Mr.
What's the timeline?
they're determining what the time frame is, but again, that can still be determined by Attorney Miller to make that based on the law itself. He will add that clause in there. So, these are major violations, and we gotta set a precedence out there.
If I may speak.
Yes, Jim.
Sorry, Commissioners.
Yeah.
Oh, okay.
Attorney, do you feel that it's still, can that still be decided on based on your legal?
Well, first of all, I just rapidly moving through here, I haven't found a specific period of time. Nonetheless, the law says if parties haven't agreed to a specific time period to remedy a default, then a reasonable period of time shall be imposed. It'd be up to you all to decide, you know, it's 30, 60, 90, 100, you know, some number of days, which it would be, our view would be reasonable to cure the defaults we've listed.
Based on the ramification of what's going on, I believe 6 months, 120 days, will provide.
180 is 6 months.
180 will provide sufficient time to cure the default itself and put it back to the golf course. The neglect of just the golf course itself and the neglect of following the lease agreement, it's alarming red flags. So I do make that motion, Madam Chair.
And the timeline is 6 months?
6 months to cure the default, to cure the. Everything
And
that's.
just so everybody understands, 180 days goes by, on the 181st day, we'll be back out on the property, and we would expect to find something that looks like a golf course. And if there is not, then we would file suit in court to terminate the lease for breach of the lease. You know, if one might imagine, you know, we could sort of have a debate about what a golf course, what is a golf course, and how, you know, what does a golf course really, what does this property really need to look like in order to qualify as a golf course?
So I do thank you for clarifying that. So basically, we've got 6 months, a notice of default will be sent out to cure. If they don't cure, we file a lawsuit to terminate, right? That's the motion. 6 months is more than enough time to fix it. and it's reasonable, so they can't come back to say it's not reasonable.
Can we open for discussion? Or it's a
After
motion?
the vote. after you-
We'll need a second before we move to discussion. If, or the motion fails for lack of a second.
I would like to discuss before I make a vote. Because I have questions to ask. Of course, the option to terminate because of non-compliance is there. But go ahead,
It's either you second the motion or you don't, and the motion dies.
no, I'll pass.
So you don't second. I won't second the motion either. Motion fails.
Motion fails.
Because I have a question. But go ahead, if the- and you can make the motion again after we address the question.
Well,
Is your motion, you pass, being passes fail, or passes, was,
The motion
it'll
fails.
come back to him, right?
I would, you know,
it failed.
after Commissioner Herrera asks his question, each of you is free to make whatever motions you'd like to make.
You can motion the same again.
Mhm.
So I'm gonna pass and then I wanna ask the question.
I think you need to take a vote, count first before.
Right?
Well, no, it
Yeah,
fails for lack of a.
Commissioner Ibanez can request for his motion again after I ask my questions.
If Commissioner Bordalio's, Chair Bordalio's recognizing Commissioner Herrera, we're happy to take whatever questions for a few minutes.
Commissioner's motion is not dead. I mean, I just wanna ask a question, but because of the parliamentary procedure, right?
He'll
that's-
have to make his motion again.
Right, yeah, and you're free to do that.
So
Okay.
it is.
And if someone wants to make a comment outside,
So, proceed.
you can ask your
All
question.
right, so motion fails.
Yes.
Motion fails.
So here's my question hypothetically, right? Let's say we say 6 months. So within the first 6 months of probationary period again, can we at that time start doing the process of request for proposal for any interested parties that wants to come in and submit a bidding to operate the golf course? That's question number one.
That will be after, if an event that they're in default,
Right,
And
I
they don't
understand.
cure?
Yeah,
and we file a lawsuit.
yeah.
Once we terminate the lease and it moves forward, then we
I
can put
think
the
that's
proposal
something
out.
that the
What
attorney
is
should
it?
answer.
Can we do it concurrently?
Right, because my object here, right, is that, of course, our mission is residential. So this is one, what's that? One lease that's producing cash flow at least $26,000 a month. I know that it's in arrears. The intent when Commissioner Garrido provided this option of a probationary period, in good faith, we voted that we were gonna provide that option to pay down the 900,000. They're down to 4, and then they're paying the monthly pay. So now, so let's say we chop the neck off this goose. Then my question is that in the interim, if even today, right, we cannot get the 166 lots going, that's number one. Really, 166 lots. We cannot even get the planning, the bidding, the options. I know we're saying, oh, this is not germane, right? But our target, like, we know our mission is residential and agriculture. Then we were given the opportunity to have about 10% of the inventory for commercial, 9%. So the question right now is that what is the cash flow since we were given that opportunity to create a cash flow? About 500,000 a month or a year,
We're collecting now in that range.
in that range. So my view on this one is that CHamoru Land Trust has 1/3 of Guam's property, 1/3 of that property that we see out there. And we can only generate 500,000 or less with all the commercial, options that we have. I'm saying we failed the trustees in the residential side. We failed the agriculture side. Why? Because if we really fine-tune this 200 acres of golf course, am I in favor of the golf course? I'm not in favor to subsidize the sports activity because for one reason, our main objective and mission is residential and agriculture. But we were given an option to use 10% of the inventory of the 11,000 acres to generate. So on this option now that we're saying we're gonna make a motion to have this company to be in compliance within 6 months, I would say that's reasonable, but we have to go back and look at the origin of this one, of this case, because our intent was to develop the 166 lots. Correct me if I'm wrong, because if anybody had,
No, we have money for that. We have money, we have 7 million sitting in the, right?
not yet, that's
Commissioner
appropriate
Herrera,
if there was surplus, if there
the-
was surplus. I
Commissioner,
understand.
the answer to your
But-
question
Yeah,
is that it would be legally imprudent to publicly be soliciting alternative lessees. We could certainly, internally, we could do as much work as possible so that once we got to a final legal conclusion on the status of this lease, the next day, we were ready to go with a Plan B, but it would be legally imprudent to publicly talk about Plan B while we were still fighting about Plan
and
A.
it's working in parallel now. The 7 million that Commissioner Ibanez was mentioning, I understand, we've been working on that since the last 2 years, the funding option. But is that 9 million or 7 million sufficient to cover the 1/3 or 11,000 acres? No. Right? No. We have development in Jigu, Dedidu, Hagad, Umakdag, Malesu, Talfofu, Inalahan. 9 million is a fraction to develop that property. 9 million, even 20 million, even 500 million, it's a fraction. We know. So what I'm saying is that this is like, we're trying to make this income producing property that's 26 mil, 26,000 a month to produce more, which is, the computation was $9 million for 30 years, correct? Above, no? So then there's an additional 7 million that Commissioner Ibanez is saying, so we put 7 and 9. You can say about maybe 7, 14, 15, 20 million. And that's only for 166. We still got the Jigu lots, the Dedidu lots. And we know that our estimate for every mile is about $1 million a mile, maybe more now. So I'm in favor to make a motion to have the GICC be in compliance within 6 months. But remember that in good faith, we were saying that we were in a transition. We made a resolution, and we agreed on a resolution to convert the property from a golf course to an income-producing solar farm. Now that's just the surface of what was projected. And like they mentioned in the earlier testimonies, that if the legislature doesn't get enough votes, then we're back to golf course. So what I'm proposing is to do a parallel to the request to invite other potential golf course operators. At the same time, we're giving them the 6 months, GICC, I mean, to comply. So in good faith, they were in that transition that most likely maybe 90% that the legislature was gonna approve the conversion of the golf course to solar farm. But we can see, you can read the media, the propaganda that's being planted on the pro side, the opponent and the proponent. So who's winning right now? The opponents or the proponent? So right here, we're now at this table and we're saying we're gonna vote for 6 months to comply, put it back into golf course operation. But knowing I work for the hill up here, and we're only about 30% of passengers coming in. 30%. Somebody here said 50%. We're only about 30% of the estimated tourism that comes in here, which is about 1.6 mil, 1.3 mil. You got about 40 flights coming in, but those flights are about maybe half full, maybe 1/3 full. We don't have it. The cash flow, even up at the hill, I'm talking about where the landing fees are at, it's not there, maybe 1/3. So now, back to this one. So am I gonna vote now when we're gonna do another motion to say, you got 6 months, JCC, get it back to normal? So my question is that if we can do a parallel at the same time.
I believe Attorney Miller answered your question on
Yeah.
that.
So we can, internally, that's what I'm
We
hearing.
can, internally we can, it would be legally imprudent to publicly,
Imprudent but not illegal.
So,
we would be, excuse me, we would be damaging the success of our eviction lawsuit if we were at the same time negotiating with the next tenant, because the GICC folks would raise issues of fairness.
Negotiation but not ratification. We're not gonna sign any, we're seeing what's your proposal. Just like what's going on with GPA and the CCU, there was a preliminary proposal. No contract yet. So if this happened there, then what's good for the geese may be good for the goat. That's on the golf course. I mean, it's supposed to be geese and the goat. But you catch what I'm saying, right? I mean, you make a motion now.
with that.
Commissioner Ibanez,
with that-
make your
that,
motion.
Madam Chair,
No, first I want, you make your thing.
I make my question.
Someone wants to make a comment. No, Mr. Tang.
Thank you, Commissioner. I'm glad I stuck around because what's that, I almost missed this stuff. What's that, there's a couple of things I want to talk about. What's that, first, what's that, I just confirmed with Yogi in terms of the alleged breaches of the lease agreement. First, I appreciate Attorney Miller that it's true, we are in substantial compliance with the rent provisions. What's that, it might be, some certain months might be a couple of days late or a week late, but the fact of the matter is since our promise with Commissioner Grillo was that they paid over $400,000 in catch-up arrears plus the current rent. That can't be disputed. Number two, I just confirmed that the well inspections have been done. They continue to be done quarterly. If they had missed, if there was an oversight that they didn't provide Director Cruz a copy of that, they can rectify that right away. Now, the third thing I want to speak about is about the violation of the requirement to use the land as a golf course. I think Attorney Miller kind of briefly touched upon that. Was that in good faith we were working with the CHamoru Land Trust on a different plan, and that plan we tried to implement that through legislation. And there was a legislation that that we appeared for the public hearing. So it's not like we didn't make any effort or progress towards that. There was a public hearing that was attended by Director Cruz and also Commissioner Herrera. And there was a technicality, at that point in time, the resolution, we were so close, the resolution was going to be introduced. But because when it was motion, when this body moved it into, when the body moved the resolution for a vote, it was misreferenced. The resolution was misreferenced. So we had to withdraw that it was withdrawn as a technicality. And so there was some delays on that. What's that, so, in terms of like, acting in good faith, working together for land trust, what's that, I think that's what we've been doing. And I think there's a question about the technicality of the default, but there's also a bigger question. What direction does the commissioners, what direction does the Chamorro Land Trust want to do as a matter of policy, as a matter of fulfilling its mission? Now, we talked about the $9 million, it's not, it's like, well, it's kind of like, it's a lot of money, but it's a drop in the bucket in comparison to what the Chamorro Land Trust needs. But I'd like to, in just hearing today's discussion of what's on the agenda, what's that, there's a, I understand that there's a RFP for office space. So what's that, one of the things that the bill that addresses, and still going to address, is a permanent home for the Chamorro Land Trust. And I don't know what type of rent you guys are paying now, right? But what's that, in the long run, that's a permanent savings moving forward. I don't know how you put a dollar value on that, but it's permanent. What's that, in terms of, at the end of the lease period, how much improvements is going to, I think this is actually a game changer. If this is a game changer for the Chamorro Land Trust in perpetuity, if this is converted to a solar farm. The sun is gonna be there for the next billion years. As long as humans are around, we're gonna need electricity. And what's that, so at the end of this lease term, I know the commissioners, up to Chamorro Land Trust, whether we remove all the solar panels or to continue, and Chamorro Land Trust can own the improvements, right? That's under the lease agreement. What's that, the improvements is the Chamorro Land Trust property at the end of the lease term unless you want it removed. But I would recommend, just from a business standpoint, that is almost $300 million in capital improvements on that solar farm, and you'll be able to sell the electricity directly to GPA, right? I think that, what's that, and that would be a game changer, So I like commissioners to think about that. What's that, there's always gonna be a market for electricity. I promise you that, there's always gonna be a market for, and what's that, and again, the opponents of the bill over here, what's that, I just, for the life of me, I just don't get how do you prioritize. I think they're a little out of touch. I mean, I'm hurting, the power bills are high, groceries are high, inflation is high, right? Cost of living is high, minimum wage has not gone up. It has not kept pace with inflation, and we have people here like just ignoring all realities, like, hey, you know what? We want golf. There's other golf courses on lawn. And they still haven't explained why Chamorro Land Trust has to subsidize it. I don't get that. What's that? So I mean, so there's a policy question. Yes, you could make the argument that we're in technical default, right? But let's go answer that policy question. What's that? So anyway, I've taken a lot of your time. Thank you, Commissioners.
Madam Chair, with that said, Madam Chair, I'd like to reintroduce a motion to terminate the lease. Give them 6 months to cure the default. They understand that they have a lease agreement, they must follow the lease. If we allow this to happen, all our other leases will have if it's not transparent, they can do it, then so can I. So we have to set the precedents to enforce our lease agreements, to ensure that payments are being made, they follow these agreements. This is Chamorro Land Trust property, it owes to the people one. And when they entered the lease, they knew exactly what they needed to do. So I make that motion to terminate the lease, provide 60 days to cure the default,
6 months.
or 180 days, 6 months, to bring the golf course into compliance with golf course remedy all the violations. Although they say that they do have it, we have not seen it. It's an obligation on them to provide it to us, not for us to ask it. It's an obligation for them to pay the bills, not for us to ask it. That's part of the lease agreement. Our fiduciary rights to ensure that they comply with the terms and conditions of this lease. And that's my motion.
Question?
Our legal counsel prepared the legality of the letter to ensure that everything that we covered is in legality. Based on, especially knowing that there was a notice that was sent out, this also provides legality and insight to document this. And even with this, it says that you must hear, and to this date, we're already in mid-January, they have not seen any type of action. So by doing the 6 months, it's now giving them more enough time to cure this thing to a golf course. Because right now, based on this letter, they have not shown efforts to make some form of at least fix it. I'm more concerned of transparency. I'm more concerned of setting it right so that all our other beneficiaries of lease agreements can see that these lease agreements should be followed. So the motion again is to terminate the lease, give them 6 months to cure, and if they don't cure, we effectuate the termination process via court.
And if the bill passes to become law, to convert it to golf course?
Well, the bill can't pass without, I mean, right now they must comply with this agreement with the CLTC. They must get approval before they do anything, because part of the lease agreement, you must go through us first, legislature, the governor, to get approval to do a repurposing of a solar farm. If you read, if you see that lease agreement, it does specifically say that. So you cannot do it and then ask for forgiveness later. You gotta ask permission first, get the approval from everybody, and then say, okay, we got the approval, let's go to the legislature to get the approval. Then the governor can come in and say, no, I'll veto it, or I approve it, right? Because you already got her consent. Now you go to the legislature, she has to approve the bill. Then that follows your process based on my understanding of this lease agreement.
So deferring the question to Attorney Miller, if in 3 months the conversion is passed and ratified, how does this 6 months?
Well, I'm gonna guess that the legislature would put a sentence or two in their bill that directed the commission to, notwithstanding, the ever popular notwithstanding, that GICC isn't using the land as a golf course, nonetheless, do a lease with these guys for a solar farm. That when you write the law, you can fix a lot of problems.
Yes, that's like the golf course, the raceway, notwithstanding, non-commercial lease. So what's good for the raceway can be good for the. So I second the motion.
I can't ask a question, it's too late, right?
No, it's,
So we have the motion already, he seconded it, now we just go through the approval process, all in favor, and then answer the question.
He second?
Any motion?
if you have a question for me, I'm more than happy to take it.
Yes, the bill that they had, it went up to close to $1 million, and that was, in 2023 of April. Now the bill is down to $414,526
And 12 cents.
and 12 cents. Is that in good faith that they tried to pay?
As we've said, several times today, they are in substantial compliance with their obligation to pay.
Substantial.
Yes. But we do have to vote on the motion.
So Madam Chair, if in the event that within this time frame, we give them 6 months, that they default and not make the payment on a monthly basis as part of the lease
Yeah,
agreement, then they can
they're-
terminate.
but they're following their lease agreement.
Right, but we also got the other.
I mean, not the lease agreement, but the agreement to pay back
That's,
in good faith.
that's one part.
I believe that's a very crucial part. That's
But
income.
that's,
That's income.
yeah, but we have a motion already on the word.
We do have to vote the motion.
So the second,
You second?
yes,
I do.
All in favor, say aye.
aye.
All opposed?
Opposed,
Nay.
nay.
Motion fails.
Hmm.
Tie.
Oh, I mean, she's voting,
No.
Nay.
well, we're, but,
The chair voted no.
so I think we need further clarification, because the chair votes on some occasions and on no occasions. So in certain situations, you get a vote of, sometimes there's no vote as part of her
It's-
commission.
It's, ultimately, it's her prerogative.
Okay, so it fails.
Fell.
Can I vote twice?
On the day,
Um,
Mr. Ibanez is not saying
no, but I'm concerned of the lease agreement, I'm very concerned of our ability on our mandate that
I
we,
can understand your point.
it's not about the money, it's about following the lease agreement and ensuring that the payments are coming in, that's not a concern.
But that was the agreement in how they're gonna pay back.
No, that's not a concern, the concern is all the other violations of the lease agreement and the golf course not being a golf course. You see, the payments are still coming in,
Out of order.
the payments are still coming in, but we're not seeing.
We're out of order,
So,
you're out of order.
Madam Chair, due to the fact that Attorney Miller needs
Yes,
to.
yes, Denise.
Can we recess until next week, Wednesday, the 22nd?
do
Wednesday?
do we still need regroup in our meetings?
There's gonna be some items here that you may need some legal guidance. But it's up to the board, I'm
Yes,
just
you
asking
do,
to recess.
because there are some that is definitely a question.
So resumption next?
Wednesday, the 22nd at same time, 1 p.m.
I don't recommend
Madam Chair, I'd like to make a
No,
motion.
you got motion, you got one, right? I don't know what, you still got one?
Check your schedule just to make sure.
No, but if I can't make it, then we have a quorum.
Just as
Yes,
long
we
as
do.
the 3 weeks.
Okay.
What happened?
Motion to
Huh?
go on recess
Uh,
until
You're still running?
January 22nd, and it went over
1 p.m.
1 p.m.
But I guess you can record these recordings.
We'll see you Wednesday.
The second,
No?
For next week?
for next week?
For what? For recessing?
Yes,
Um,
January 22nd at 1.
oh, yeah, oh,
I made a motion here for next Wednesday. 22nd.
He needs a
One
second,
p.m.
or else we don't go on recess, it ends. Call Mr.
Then Mr.
Yeah.
Commissioner with the rest.
second?
All in favor, say aye.
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 Thanks, Duncan.
Recess, okay. Now, for the